Very good morning. How are you? Yes. So, good morning to our friends who have joined online as well. Right. So, I welcome you to this foundation revision series of Bharadwaj. So, already you would have completed a couple of subjects, right? Maths and accounts got completed. Today we will be starting with law. So, the scheme of our 3 day session will be on. First, we will be having we'll go in the order. So first we'll have introduction, subsequently by Contracts Act. Tomorrow, the second day, we will be having Sale of Goods Act and Negotiable Instrument. And subsequently, on the third day, we'll have Business Communication and we'll have 100 kind of MCQs which to be tested. So similar way, right? Clear? So stop me anywhere in between in case if you have any doubts. No problem. We'll get the doubts clear and go forward, right? And already this material has been shared both on WhatsApp as well as the Google Drive. You can still have access to it anytime. Okay, clear? Can we start? Yes. So the first part is on. We are having this introduction to legal framework. So we have already seen, but I have made it comprehensive so that it is not just a revision session. So it will be having a refresher on the entire syllabus which we have seen. Okay. Only thing is I have put it into a different form rather than text. We have seen it in different forms. That's all. Now, starting with the sources of law. The introduction of legal framework starts with law. What do you mean by law? It says about law is just a set of rules. What is the purpose? We have already discussed enough in general, right? In general, in our classes, we would have discussed for the benefit of all those people who are joining online as well as the new students, right? Who are giving the exams for December foundation. So, set of rules is we understand. Apart from that, what is the purpose of set of rules? What would I have seen? What is the purpose of these rules? Rules we understand. What is the purpose of these rules? Very good, very good. To maintain a standard behavior, right? So it is to that we live in a society, and the society requires some sort of behavior from the mankind. So to shape the mankind to be admitted into the society, all acts to be admissible. So you are giving this set of rules. You have to follow this being part of the society, right? So that is being insisted. They are trying to keep their words. Good. We just started. They're waiting for you, but we just started. So we start with concepts of first chapter where concept and source of law. What do you mean by a law? It is as actually a set of rules for the purpose of the men to upgrade the behavior to be accepted by the society. Whatever the acceptable practices in the society, we have to take it up, right? Then the founding stone of law in India is being vested on what? This thing called Constitution. Constitution of India, right? Constitution of India speaks about many things. Constitution in simple, I will be speaking about three wings of Constitution or three hands of Constitution. What do we call it? That is the law making, legislative making powers. Three wings generally. Legislative, what is legislative? Law making. Then legislative powers, I'll say powers, executive powers, then something very good. Judiciary, right? So executive, legislative and judiciary, they put in order legislative, executive and judiciary. Legislative makes the power. Who tries to implement it? The executive powers. For an example, we have a traffic rules. Traffic rules is being made by the legislative. Then we have who are enforcing it. Who is asking you to wear helmet? Who is asking you to follow this thing? A police officer who is an executive person of the law. So executive authority is there. Then finally, in case if you have a problem, you say that you didn't cross the red signal, and he says that yes, you did cross. Where you will go? judiciary, to the court, and say that you will try to prove yourself, he will try to prove himself, right? So that is where we win. See, these three are the hands or wings of the constitution. Going by that, who gives the power to them? Who gives the power to the legislation to make laws? Who gives the power to the executive authorities to implement and take action over it? Who gives the authority to you to go and fight against in the court? Everything comes under the Constitution of India, where Constitution of India not only gives powers to the lawmakers, it also gives powers to individuals. What do we call that? Rights as. Individuals has rights, right? We have rights. What do you call that? Yes, fundamental rights. Part 3 of the Constitution is envisaged with fundamental rights which you and me can access to it. So all those are the basic founding stone is from Constitution of India, which year? 1950. Clear? Then under that, what are the sources of law we are looking at? There are 4 sources which we'll see here. We are putting this case laws as well as the personal laws together, right? Clear? So one is statute and delegated legislation. Statute is nothing but the law made by the parliament. There we are making into 2 differentiations. One is primary as well as delegated. Delegated is also called as secondary or subordinate legislation, right? So primary laws are what? Which is made by the parliament itself, the state legislature itself. Parliament is making a new law, or state legislature of Tamil Nadu or any state legislature is making a new law. We call it as, it is the legislative party. They have the power, they are making the law, then we call it as a primary legislation. Right? Below them, there are authorities, executive authorities. There are many intermediaries between the lawmakers and the individuals who are accessing to those rights. The departments of the government, ministries, they make their own law for what? For effective management of the affairs, day-to-day affairs. Law only says if you want to do this, you want to get registered as a company, you want to get registered as a LLP or a firm, this is the procedure. It will say that you have to make an application to the registrar, file a name application form, incorporation form, you will be registering. But that ministry would have what all you should submit as documents for the purpose of registration. In those cases, the first level law which is made by the parliament is called the primary legislation. The subsequent level, the ministry or the departments, in order to bring in necessary grassroots level, grassroots is what? Bottom level. Bottom level affairs has to be made. For that, they are making regulations that we call delegated legislation. You have to know the difference between primary and delegated or subordinate or whatever it is. What is the other name? Right? Secondary legislation should be named into. Clear? So that is one of the main differences. Then primary legislation, how it works. Now comes to the part which you said. The 7th schedule of this Constitution of India. 7th schedule is nothing but the Constitution of India is going to say about what? There are many rules. There are many rules which we are looking at. Right? So this list is going to say which are the items. The list is going to have, for an example, income tax matters. Who has to make laws? Right? Union. Union will be the one to make laws. Generally, a matter which is going to be applied to entire India would be like, definitely it should be with the union, right? So wherever it is going to be the areas which union can make powers, union list is going to say, state can make laws, state is going to contain, and whenever it is going to be both union and state can make laws in certain areas. So in those cases, we call it as concurrent list. Both can make laws at the same time. What if in case of a conflict? There is a state law as well as a union law which we are looking at. It has a conflict. State passes some law, union also passes some law in a concurrent list, but there is a conflict between them, inconsistency between them. Which shall prevail? Union shall prevail. Very good. Union shall prevail. So the 7th schedule, I am just keeping the most important part of it which could be asked as a question. So 7th schedule could be a answer. Which part of the Constitution of India has the bifurcation between union, state and concurrent list? It shall be 7th schedule, right? What is the primary difference between a primary and delegated legislation? Laws made by the central government and authorities, we will call it as delegated legislation. But it's going to be the parliament or state legislation, we call it as primary legislation. They may give an act, GST Act 2017. Is it a primary or a delegated legislation? Primary legislation. It was made by the RBI rules. What legislation? RBI rules. RBI Act could be primary legislation. RBI makes rules for the commercial banks, for managing the affairs of the commercial banks. What could be called as? Delegated legislation, because RBI is making rules for them. RBI is a representative of any people. RBI is not part of the parliament. RBI is a regulatory body under the government. RBI makes rules for itself to manage the grassroots level administration. So for those cases, it will be different. So you can be very clear that whenever the act is being made by the parliament or state legislation alone, you can consider as primary. Remaining things with respect to any authorities, regulatory bodies, ministries is going to pass any rules, regulations, right? Those are coming only into the delegated legislation. Clear? Clear? Moving on to the second part, case laws and personal laws. What is case laws? Case law. Already decided case laws. The court has already decided on some matter. We call that as, in a different word, as judicial precedents. Already a court has judicial precedent. Already a court has decided on some matter. Next time you need not go for another time interpreting the same law. Let's assume there is a traffic violation case where one person has been acquitted, means not convicted. Convicted is you are confirmed offender. Acquitted means he was not found guilty and he was left. Same scenario comes for another person. Should again they have to do the entire interpretation of the law? Not necessary. They will just refer to similar case was there. At that time we acquitted. The facts of the case of this case also similar to that. We are going to acquit this person. So in those cases, what do you have to do? It is a reference. It is already made as a law to be followed. We need not go for any new interpretation. There is already a precedent. We will follow that. Then, when it comes to personal laws, it is purely on the individual faith and beliefs, where individually I might be following a religion. That religion would be having some specific laws. For an example, the succession of property for Hindus is being governed by Hindu Succession Act. Marriages, Hindu Marriages Act. We have Christian Marriage Acts. Right? Islam has a Mohammedan law. They will follow their respective laws. If an individual is going to be tried on certain offences and it is going to be based on the personal laws, we will apply those personal laws, not on generality on a few aspects. Right? Then these two are going to be second and third sources of law. The last one is on ordinances. Where do you heard that word? Ordinances. Ordinances. Who makes the law? Legislative makes the law generally, right? The primary legislation is being made by Parliament or the state legislature when it comes to the recess of the interval period, the break period, where we think that all 365 days Parliament and state legislature is going to sit and make laws? No, only they sit in sessions. So between one session and second session, they call this period is called recess. Immediately some law has to be made. Immediately some law has to be made. An urgency. So who gets the power? President will be having the powers in case of a overall India nation, and in case of a state, it will be having the power of governor. So they will be making laws. So that comes under this category, where under Article 123, easy to remember, 123, President is having the powers to make ordinances. Similarly, in case of a governor, under Article 213, which is a transposition of 123, you can still remember 213, right? So these powers have been vested with President and Governor. At the time of emergencies, they will be able to make laws. Clear? Then, apart from that, there will be local panchayats and all, they will be making rules. For an example, the tax on profession. There is a tax called tax on profession. This local land revenue, all these things are being left out with the local panchayat. They will be making laws. This tax on profession will be purely onto the local municipality or panchayat, or in case of the Greater Chennai Corporation, it is a corporation which decides it. Nobody else will come and intervene into it. So those regulations passed by the local administration will also to be considered as reference to a law which is under Article 243. Clear? So this page, this first page is going to only say about what are the sources of law. It's a very basic thing. So what we understand, the concept of law is basically law is going to be set of rules, right? Then which paved out the foundation for it? Constitution of India paved the foundation for it. Under that, we are going to take, there are four sources. We are putting into three. There are four sources of law. One is the statutes and the legislation which is passed by the parliament or the state legislation, which we call it as primary legislation, or the departments or the authorities, government ministries is going to make regulations, grassroots level regulations. We call that as delegated legislation. When we have, then we have case laws, which is called judicial precedent, already decided case laws, which is also forming as a source of law. We can derive inferences from them, right? Judicial precedent. Then in case of a personal laws is also an customary, personal and customary laws is also an sources of law. Then we have ordinances, which in case of a recess period of the parliament, the president and power has the power to make laws, urgencies. Exigency is the word used. We will be seeing in one of the other pages. So exigencies is the word used. So there we can find it has been taken up. Clear? Then again, regulations of local representatives, local authorities, administration can also be considered as under 243. So the section numbers, sorry, the article numbers, here it is article numbers. Always remember, only in Constitution of India we refer to articles. All other acts we refer to as section 10, section 25, section 31. Right? Here only we refer to as under Constitution of India, we will be referring only as article. Clear? Clear? Good. Can you move on to the next page? So again, the legislative process in India, the first primary legislation we saw, right? Primary legislation. We say that the parliament and the state legislation will be making laws. Under that, when we say parliament, who are all involved in it? Who are all involved in it? So first we will take part by part. The Constitution of India gives the power. Please understand, who gives the power to parliament and the state legislature to make laws for India, for state legislature? The Constitution of India gives power, right? So Constitution gives power to the parliament. How? You can make laws, but you have to follow this procedure. The procedure is you make a bill. Bill is nothing but a draft law, right? Bill go to the parliament. Both the houses of the parliament has to approve it. Then who has to assent? Somebody else has to assent. President, right? President has to assent. So all these three people has to be part of the law making of a primary legislation. So it says where you will have the Council of States, which is Rajya Sabha, House of People, which is Lok Sabha, both has to approve. Then it will go for the president assent and they will become a bill. Right? There are certain exemptions where introduction of bills into parliament. I mean, for a purpose of passing a bill, you have to introduce it, right? So, which house to be introduced? There are two houses, which is Lok Sabha and Rajya Sabha. Which house you have to introduce a bill? Very good. Excellent. So, in case of a money bill or a finance bill alone, you cannot directly put it to Rajya Sabha. You have to go through the process of first Lok Sabha, then Rajya Sabha. Other bills, either house of the parliament, the language they would have used is the bill may originate from either house of the parliament. So it can be either from Lok Sabha or Rajya Sabha. First Lok Sabha can approve it or Rajya Sabha can approve it and Lok Sabha has to wait and do it, means please do. Once they get the approval, they will go for the president assent. Okay. So three elements to be fulfilled. Both the approvals of Lok Sabha, Rajya Sabha as well as the president's assent. We call it as assent, right? The president assents to be taken up. Based on that only a law will come into force. The similar case in case of a state government, you will have legislative assembly. This is the only place which we are looking at. Very few states has this legislative council. That's why I have given in a dotted manner in the book. Maybe in the material, if you can refer to, it will be clear, right? So it is where it is not all states will have legislative council. Very few states has legislative council also. Most of the other states, only the legislative assembly makes the rules and governor will be informed about it. See, please see, we have made a law and then it gets applicable. Right? This is what the legislative power, legislative process. However, new law is made for a state or India, it is to follow this procedure. Right? So who gives the power? Again, the Constitution 7th schedule which we have given. List 1, 2, 3 are the list which we are looking at. Right? Here they have given, right? List 1, 2, 3 where Parliament's exclusive power is being given. Parliament alone make laws in the union list. When it comes to state list, state alone has the exclusive power. In concurrent list, they have both. Right, good. So similarly, when it comes to there is a conflict. Article 254 speaks about there is a conflict. If repugnant means nothing but inconsistency. The word repugnance means inconsistency between a law made by the Parliament under concurrent list. They say one thing, the other people are saying something. Parliament says something, state legislature says something. As you rightly said, Parliament's law will prevail. No doubt about it, because they are having an upper hand on this. Clear? Then the process is going to be where introduction of a bill, either it is a government bill or a private member's bill. Government bill is nothing but the minister is introducing. Finance minister introduces the bill. Nirmala Sitharaman introduces a bill. Then you call it as the government bill. In case of a private member who is not a minister but a member of parliament is going to, right, other than the minister, a member of a Lok Sabha or a member of a Rajya Sabha is trying to introduce a bill, we call it as a private bill, right? Both are the same process. They have to get approved in the either house of the parliament. So this introduction, power to introduce the bill is given under 107. 107, Article 107 says about power to introduce the bill into the parliament. Subsequently, they are also saying about 109, and in addition to that 117, these two alone is going to refer to money or other financial bills where it has to originate only in Lok Sabha. In short, we are given the same thing. Clear? Clear? Good. Any doubts in this page? Any doubts? Our friends online, in case of any doubts, please do stop me there. We'll handle that and go forward. Can you move on? Yes. So this is just a similar representation of it. Bill to act, how it is going. Each house of the parliament has to take, and president's assent. You can remember even the president assent. Article 111 is going to speak about president assent. Easy to remember, 111. Which article requires president assent, or article 111 requires dash assent for a law to be moved into a parliament, means then it is president's assent, right? So both the houses of the parliament takes into account and the president accepts, and the act is being formed. So you can see that from bill to act how it is moving. Clear? Then ordinances, we have already seen Article 123 and Governor 213, and even in case of a local governance 243, which is we have seen in the first slide, it is also making temporary law. Why we are looking at it as a temporary law means it is a temporary law. The necessity to mention it as temporary law is only at the time of recess, the break period, interval period of the parliament, they are making laws. Soon after the parliament resumes, they have to keep this before the parliament and get it validated. So this period of validity may be from 6 weeks to 6 months based on the nature of the ordinances which we pass. Right? So in those cases, soon after that, Parliament gets back into house, they have to place these ordinances. See, when you are not there, we did this law, the president did this law, please approve it, ratify it. So if they ratify, it will continue. If they don't ratify, it will stop ceasing. Right? It will cease to act, it will stop. You will not have that continued flow of that. Right? Apart from that, in case if there is any amendment is required to the constitution, amendment to the constitution. What do you call it as amendment? Sorry?
Minor changes.
Changes. No, need not be minor. Any major also we can say. Right? In case you are going by this contract act, right? Change how it is being taken, whether it is an alteration or a substitution. Now here amendment into the Constitution of India. Constitution of India is a base for all, and we are going to change that. How it can happen? Again, the provision has been given. 368 is a provision which says about the Constitution can be amended. What remains to amendment means any addition of a new article, modification of an existing article, or deletion of an existing article. So they might say addition is no adding of a new article, variation is modifying, changing, or repeal. Repeal means removing. Removing of a provision can be done. Yes, Constitution has given power. 368, Article 368 is going to speak about the powers of an parliament to amend the Constitution. Type of amendment can be given. Clear? Then unconstitutional amendment. Okay, sir, we are making an amendment to the Constitution, but it is going to affect the fundamental rights. Fundamental rights are envisaged in Part 3 of the Constitution of India. It is affecting the fundamental rights. What happens? One of the case laws where Keshavananda Bharati versus State of Kerala, they are insisting that, just give me a minute. Yes, so they are insisting that the fundamental rights is always above all. You cannot pass any new amendment which is going to affect the fundamental rights. You have all this right to be equal, right to equality, right to freedom of speech and expression, right? All these rights are, one of the rights is going to be where no discrimination in case of a public offices. In government, you cannot, except for the reservation mechanism, the other ways you cannot make a discrimination on any grounds. All these things are rights to you, but the new parliament is going to pass an act. I mean, the new parliament which is getting formed is going to pass an act which is going to affect these fundamental rights. Can you accept it? Sir, they say Article 368 has the power to amend the articles. We are going to amend in such a way that it is going to affect fundamental rights. The makers of the Constitution of India, who made it? Who made it? Sorry? Who made it? Who wrote the Constitution of India? Correct. Dr. B.R. Ambedkar. He chaired the committee. There was a team under him, right? Who wrote the entire. They were very clear. Definitely, the upcoming governments will try to change something which might affect the fundamental rights. They made it very clear. If at all any amendment which is going to come and affect the fundamental rights will be the one to be holding an upper hand. So they say, in case of any amendment which is coming, it is being re-emphasized in the case of Keshavananda Bharati versus State of Kerala, where any amendment which is going to affect the fundamental rights would be declared as unconstitutional amendment. The word unconstitutional was referred in this Keshavananda Bharati was the state of Kerala. So, if it is unconstitutional, it cannot go. Fundamental rights will have a higher weightage than any amendments. If at all it is going to affect the fundamental rights, you cannot go ahead with this amendment. 368 is subject to fundamental rights. If it is going to affect fundamental rights, we cannot go for that amendment. Will be declared as unconstitutional and be done. Right? Clear? Can you move forward? Yes. The next slide is kind of a loaded slide where there are certain changes to here with respect to not to our syllabus. In the real-time scenario, there are changes. I'll just keep you informed of for your knowledge. Otherwise, you can just still follow it. The same course structure which would have known. Topmost court is what? Supreme Court. Below that, high courts of every state. Every state has a high court, right? So earlier we didn't have this. Post to the Constitution of India stated that at least one high court should be there. Every state shall have one high court, right? Then subsequently we have subordinate courts both under criminal and civil jurisdictions, which will be differentiated. It's just a very slide of hierarchy between the courts, how it is being there. It starts with Supreme Court of India and it is apex court where there are certain jurisdictions which he can exercise. They have the original jurisdiction on certain matters. The first point under this, what is the original jurisdiction, is nothing but they can here take direct cases of what? State, one state, another state, state and center, there is a problem. They can take this case. So let's assume Karnataka and Andhra has a problem. They want to file a case. Which court they will be filing? Why? Because if they cannot go and file in their own state courts, obviously their state court will be supporting them. Right? So you cannot do that, you have to go to central. So very clearly, in case of a state versus another state or state versus center, you have to approach to the Supreme Court. Then writ jurisdiction. What do you mean by writ jurisdiction? Fundamental rights are getting violated, right? They are saying that every citizen of India can approach. Article 32 says about when your fundamental rights are violated, there are 5 types of writs we might have seen in the earlier classes when we expanded it. Which movies are all has included writ of habeas corpus to find the person and bring before the court. Writ of prohibition to not to do something. All these writs can be filed against the public department, right? So those writs can be exercised directly. Article 32 allows you to file a suit under Supreme Court. Not only under Supreme Court, even the same similar cases under High Court also under Article 226. Very good. 226. There. Here, so we'll be seeing that the High Court. Then apart from that, appellate jurisdiction. Appellate means what? Appeal. Appeal is going to the next level court, right? So High Court has ruled a case. Now you want to go against appeal over it. Where you can go? Only to the Supreme Court. So it accepts all the appeal jurisdiction, not only to the High Court. Is there anything else we can go appeal under Supreme Court? No? Think about it. Sorry? High Court we understand because above High Court it is only Supreme Court. We'll hold on to that for now. The subsequent slides has the answer for whether it is only High Courts has the appellate jurisdiction in Supreme Court or something else also has the appellate right to Supreme Court. Right? We'll hold on to this question. No. No, obviously subordinate courts will have go High Courts, right? The hierarchy says that subordinate courts you have to go to High Court. Only after that you will go to Supreme Court. Sorry? No, see, Parliament is only a law making. He will only write. They will not make any interpretations. We will see that. Now we are speaking about appellate jurisdiction. Appellate jurisdiction is where We will hear appeals. Oh, below me that person is there. He told that like, let me hear that appeal. I will decide what to be done. So High Courts, we understand Supreme Court has this. There is a one other person we will see in the very next slide we will see. Okay. Then when it comes to advisory jurisdiction, President needs an advice on some law. Who has to come in? The Supreme Court will be doing the advisory for the President. The punishment for content relating to some we see now in the news. Supreme Court orders something to a state government. State government doesn't follow. They will say you are contempting the court's direction. Then review jurisdiction on its own judgment. Review is something, there is something called review as well as revision. Review is where you do your review of answers. We say that means what? After writing your answers, please review it means what? You go again and see whatever you consider is right or not. So review jurisdiction is also being exercised by the Supreme Court of India. Then moving on to the next layer down, High Courts. High Court has original jurisdiction on certain matters where it is going to be some revenues or FRs, all these things within the state's jurisdiction, state's territorial jurisdiction. What do you mean by territorial jurisdiction? Territorial jurisdiction. Within the state, they might have to exercise some rights which is only available to the High Court. Then you have to file it with the High Court. So they have original jurisdiction, writ jurisdiction on certain matters with respect to legal rights and fundamental rights. Right? Legal rights and fundamental rights. We have writ jurisdiction 226, which is available, similar to what we have seen in Article 32 of Supreme Court. Then appellate jurisdiction to civil and criminal courts. The below courts are there, right? Subordinate courts. They enjoy the appellate jurisdiction. Not only that, they also have a superintendent's power. Whether the courts under it is working fine, working as per the process, it is being ensured by the state level high courts. And the last one, similar to that, where punishment of a content will also be heard by the high court. Right? Under that, we are going to differentiate the lower courts into two. One is civil court structure and the criminal court structure. Right? How to remember this criminal court structure is wherever you find this word called magistrate. Magistrate. You will always see magistrate only in the criminal court structure. Civil court structure will have judges. Right? Judges. So here you can see district court has highest court and judicial and administrative powers. They will be having court of subordinate judge class 1, below them class 2, and court of small causes and munsifs. All these things can be seen as the court structure. Right? When it comes to criminal court structure, it has court of session, sessions court of session, under them assistant sessions. Then it is divided into chief metropolitan magistrate and metropolitan magistrate, chief judicial magistrate, first class, second class, and special judicial magistrate, who are executive magistrates. Just a hierarchy, nothing to worry about, just a hierarchy. You might look at ways we can remember is this. Right? Only change which has happened is there is something called the criminal. This is under criminal procedure code. Now the criminal procedure code has been. It is still there. Do you have any idea? Criminal procedure code. Criminal procedure code has been repealed. 3 acts: IPC, Indian Penal Code, Criminal Procedure Code, and Indian Evidence Act has been removed and repealed. It has been replaced by BNS, okay, BNSS as well as BNSS, BNS, and BSA. 3 acts has been. It will have Bharatiya Nyaya Sanghita, something. The name will be coming. Okay, there are 3 acts. Under that, they have just removed this metropolitan magistrate concept. That's all. That is only for your knowledge, and anyways that for the purposes of your exams, I don't think there will be any change relating to this. Right? Clear? Are we good with the court system in India? Can you move forward? Any doubts here? Yes. Then, what is this concept of tribunals? Somewhere we have seen tribunals. Judicial expertise. Are they judicial authorities?
To reduce the burden of judicial.
Yes. So what sort of authorities we are looking at? Quasi-judicial authorities. They are basically quasi-judicial. What is the purpose? As you said, to reduce the work burden of the courts, they are going to have tribunals. Not only that, very good. So as you said, expertise, subject matter expertise can also be included by hearing a case. So that is also considered under the tribunal system. The quasi-judicial is to purpose of reduce the judicial caseload and add subject matter expertise to it. There shall be independence from the executive, meaning nothing but the government will not be part of it. Because generally, apart from the court, if you hear the case, who can hear those cases? Commissioner can hear a case. Commissioner is coming under what category? Income tax commissioner is there. He is an employee of income tax department. Commissioner. Yes, obviously. An inspector of income tax comes to you and charges you a fine, and you go to the commissioner. Commissioner is also part of the system, right? Then you have to go to somebody who is independent to make a judgment. So these tribunal systems allows, they are not coming under the department, they are coming under the act, and they will say that they are not individuals who are being employees of this department. They will be appointed for the purpose of hearing the cases under the tribunal system. Okay, all many tribunals are there. We will see few examples of it. So the composition of the tribunal shall have judicial members, right? Judges and lawyers. They have qualification. High Court judge who can be a judicial member, who has served as a High Court judge for certain years, will be an experienced lawyers. 15 years, 25 years experienced lawyers will be part of it, right? Then technical members who are experts in that field. Let's assume it is relating to some labor laws. Some person who has worked in the labor law for 15 to 25 years. It is relating to costing. You are a practicing cost accountant for 25 years. Then you will be the technical member on that category. Clear? Clear? So here there is two levels of tribunal generally we look at. One is the first level tribunal and second is appellate tribunal. For an example, company law would have NCLT, National Company Law Tribunal, and above them we have National Company Law Appellate Tribunal. Appellate tribunals are there in few places. Here, so the appellate hierarchy would be like that. When it comes to something, as I told, there is some part which we are left know earlier slide. Appellate jurisdiction, not only for High Court, for something else also. What is it? Tribunals. Not all tribunals. We might have seen a structure where there are some tribunals which is equivalent to High Court, which are below High Court. Which are below High Court, where they can go? To the High Court. They are appellate jurisdiction High Court. Which are equivalent to the tribunal. They have to go to the Supreme Court. They cannot go to an equal level person. Right? So that is where. So not only High Courts, who has a jurisdiction for appeal under Supreme Court? Even tribunals, few tribunals, not all tribunals. So that is being seen. So central administrative tribunals, income tax tribunals are there. There are few tribunals where the appellate authority is going to be High Court and few places where Supreme Court. We can see NCLAT because NCLT is there, NCLAT is there. NCLAT is already a High Court level tribunal, appellate tribunal. Then you have to go to only to a Supreme Court, right? So these are the few examples. Industrial tribunals, CESTAT tribunal are going to be part of High Court when it comes to Securities Appellate Tribunal or NCLAT will be the tribunals which would be having an appellate jurisdiction with Supreme Court. Clear? That is one part of it. Then what about this ADRs? Alternate dispute resolution. Alternate dispute resolution. What do you mean by that? Very good, very good. Without judicial intervention, you don't want to go to the court, which will take so much of your time. So you think that let's handle it out of court. How we can do that? Can go for judicial, out of judicial by preferring an alternate dispute resolution mechanism. Under that, we have four things. One is arbitration, conciliation, mediation, and lok adalat. So, lok adalat, we'll see it separately. When it comes to arbitration, conciliation, and mediation, what is the common thing? It is being done by a person who is independent, and we call them as impartial, third party, impartial, neutral person. It is being done by him, right? The what process he does, what efforts he is going to take decides whether it is going to be called as an arbitration, conciliation, or a mediation, right? What does in an arbitration? Arbitrator can see this image itself and made in such a way that he will decide on it. Arbitrator, the person who is appointed under arbitration is called arbitrator. Arbitrator shall be appointed only in odd numbers. Not even, they want to make a decision. Let's assume 3 people are there. They call it as arbitral tribunal. 5 people are there. They call it as tribunal. Where you will be able to make a decision over it. 3 people say yes, 2 people say no, so 3 people is prevail. What in case of 4 people are there in the tribunal? 2 is saying yes, 2 is saying no. Will you be able to arrive at a decision? No. They only hear the case based on the evidences and give a decision saying that you are right, you are wrong. That tribunal will be the one to pass an order called. If court passes an order, we call it as a judgment or an order or a decree. When they pass, we call it as award, arbitral award. Arbitral award shall be final and binding. I am going to an arbitration. We are going to an arbitration. You and me, we go and get a decision from the arbitrators and award, and it is finally binding on us. We have to follow that. Clear? So, arbitral tribunal makes a binding award where minimal judicial intervention is there. Then, when it comes to a conciliator means he is going to, we have this something called BRS, right? Bank Reconciliation Statement. Reconciling, you are reconciling. There is a problem, I know that. We are trying to reconcile. We are trying to put up our effort in a way we could balance things, right? So here, this conciliator is not going to make a judgment over it. He is going to try, help both the parties to find a mutual solution for it. He will speak to you, he will speak to me and suggest us. He is just not going to make a rule and say that you are right, you are wrong. He is going to assist, right? He will assist. So the conciliator assists. In case of a labor issues and all, this Deputy Commissioner of Labor will be appointed as conciliation officer because he doesn't want to say the laborers are right or the company is wrong. They want, finally, end of the day, they have to reconcile and go back to work. So conciliation has to happen. We call them as a conciliation officer. So the conciliator assists non-binding recommendation. They will not say you have to do this. They will say this is the way you can do it. Please think about it. I will also speak to the other party. We'll arrive at a mutual judgment. Then finally he comes up with a settlement saying that this is what it could be done for mutually benefiting. Then it is you and me to decide whether to accept it. Until such thing, it is not binding. But I am signing that yes, you are also accepting, I am also accepting. Once you put your signatures, right, the final settlement will become binding. He will recommend. If we accept it, we have to become binding. When it comes to mediation, what happens? He will help the parties to facilitate the meeting, facilitate the parties to communicate well. That's all. He neither does an arbitrator job or a conciliator job, just mediates between them, right? So the parties are the person who is going to control the outcome of it. I don't have a choice. I'll just help you communicate. Clear? And it is a more of an informal way of communicating. All these three are coming under the ADRs without intervention of the court system. Okay? Very few places where in case if you and me has an arbitration between us, I have appointed an arbitrator asking you to come for arbitration, you are not coming, then I will go to the civil court and say that file an application for you to come for arbitration. This is the only enforceability. Otherwise, the type of nature or arbitration is going to be alternate dispute maker. I am not going to the court. Since you are not coming, to arbitration. I am going to the court and asking you, please come to the arbitration. That's all. Clear? Then the Lok Adalat, why I am not including Lok Adalat as ADR is it involves a judicial officer. It is coming under the Legal Services Authority Act. So for the purposes of ADR, I can consider as a Lok Adalat as an ADR, alternate dispute resolution mechanism, but it still has some sort of judicial part to it because you are not appointing, there is a judicial officer who's sitting at the Lok Adalat. He is going to write down your conversation. Oh, you are agreeing this way, fine. I'll put it into writing and you both sign, that becomes a binding. Right? So where it is a place in the High Court, you can go to the High Court of Madras. So you just have to see test restrictions. Sir told you can go to the High Court. High Court there is a place. Whenever you go, you can see. Okay, there is a place restricted for, specifically given for Lok Adalat. There will be a person sitting. People who are preferring to go for a settlement through Lok Adalat, they make an application, go and have a settlement written down before them and settle things out. Okay, so because they will have not only an outside party, even the court has taken on record this, that will be an evidence. Whatever the judicial officer gives will be an evidence for us. So the facility of the negotiation order will be final and binding and deemed as a decree. As the civil court, when it passes a decree, similarly this Lok Adalat, because it is a judicial authority, it is coming under Legal Services Authority Act. So even when they pass an order or give a document in order or a final settlement has been signed, then we call it as a decree which is non-appealable. You need not go because you and me agree, then how you can go for an appeal and say that I didn't want to agree that way. It's happening before you, so it is very clear that it is happening before the judicial officer and it cannot be appealable. It is binding on the parties. It is equivalent to a deemed decree. Court decree is being passed by the court, is deemed to be a decree. Right? What are the advantages of ADR? Less time consuming, cost effective, amicable settlement, less aggressive. You want to settle the things out rather than fighting it out. You want to settle the things out. Right? Those are the provisions of ADR. Clear? Any doubts? Then there is regulatory bodies. The last part of it is speaking about regulatory bodies, which 7 regulatory bodies are part of it. What do they do? What do they do? We have government, parliament, all these people are making laws. Finance minister make laws. Make laws, LAWS. You should not think that Sir told that finance minister make laws, LOSS. We are not speaking politics here. Right? They are making laws for India. Who is going to implement the authorities? For them, they can make laws which we call it as delegated legislation. They are also appointing authorities to manage things. Who are those authorities? They are called as regulatory bodies, self-regulatory bodies. They will be appointed. They will be having their own officers. They will be having their own board to manage the affairs under that act. So these people are basically the guardians or the watchdogs of the governance in their respective areas. Securities market, there is a problem. Who has to come in? SEBI will be the one to see what is required, what has to be changed, all these things. Okay. So in case of a banks, who will come? RBI. So similarly, they are giving insurance, IRDA, a very quick snapshot of what they are looking at. So it says about first SEBI, what is their objectives? To protect investors. We are all investors who are earning hard-earned money. Every month, 22 days we work, bring in amount and say that let's save and invest. We are investing into one company and that company goes into a failure, fraud, scam. What happens? All our next time will we invest? No. If you don't invest, what happens? The market circulation, the money is going to be hampered. So protecting the investors becomes a duty of the government. Through SEBI, they are going to say what is your primary aim? Make rules for listed entities handle it through stock exchanges and see whether they are complying. The stock exchange are giving extensive guidelines with respect to how you should be following the regulations, listing company regulations and the listed listing obligation and disclosure requirements, listing regulations. They have to follow. Who watches it? Stock exchanges watches it. Who gave the order? SEBI gave the order. SEBI wants to protect the investors. Okay, SEBI starts with protecting investors, preventing malpractices in the market, manipulating the market, then ensure fair markets are being available. Anything in case of a market, not only the stock market, any market which we are looking at, even the vegetable market, what decides it? Economics we study, right? Market is being driven by what? Very good. Demand and supply. If you are going to intervene into the demand and supply, you are going to make some artificial demand. Then what you are doing with messing up with the market, which is a malpractice. So it says that even in the securities trading, they want to ensure fair market to be there. Clear? That is the objective of it. What is the functions they do? Protection, preventing insider trading, regulatory code of conducts are being given, and auditing of the exchanges, right? Development with respect to training and research relating to the securities market is also being done. Then 2 is on Reserve Bank of India. We know Reserve Bank of India for at least for how many years? Because RBI would have said they are the central bank of India, right? They are the bankers for the government. They are the lender of last resort, bankers bank. All these things you would have studied somewhere in commerce or somewhere, right? The purpose for them where the central bank, they act as the central bank of India, regulate monetary policy and fiscal financial sector. Monetary and fiscal policy is being handled, and the financial sector, not only banks, also NBFCs, non-banking financial companies are also non-banking financial. Basically, they could be microfinance companies, other companies which only does loans. Why they call it as non-banking financial companies? They don't have the predominant work as banking. Banking includes only 2 activities: accepting of deposits and lending of loans, like providing loans. They might not do accepting of deposits. With their own funds, they might lend loans. They will not accept as deposits. They may take a loan and give you loan. So those will not consider as a banking. So there are many activities. Let's assume bills discounting. You would have seen bills discounting. The bank discounts the bills, right? There are now private institutions, financial institutions that discount bills. Whether they are called banks, no, they may call it as financial. They are indigenous financial institutions. In case if they are going to certain thresholds, they have to register themselves as NBFCs. They have to go to RBI and make a registration with NBFCs. NBFC is also handled by financial institutions, also being governed by the RBI. Right? What is the responsibilities? Maintain price stability, issue bank licenses, formulate prudential law, regulate reserve, print and circulate currencies. So regulation of the currency is also whose work? RBI's work. How much you print, how much you want to print, how much should be circulated. All these things are going to be in the hands of RBI. Then IRDAI, Insurance Regulatory and Development Authority of India. So name itself is going to state they are going to handle which sector? Insurance sector, right? So insurance sector. I'll just give one example. None of our insurances had COVID covered in it because nobody knows COVID was going to come in 2020. COVID-19 we call, but in India we can call only when it is 2020 March it was accepted, right? So at that point in time, whether we had already included all our insurance, the many of the hospitals rejected that this cannot come under insurance because your insurance doesn't cover COVID related provisions. Then IRDA came up and issued an order. This is a matter of emergency. You cannot say it is not covering. I am giving, even if it is not there, I will say it should be included. It is implied that it includes. So in those cases, who controls the insurance sector in India, IRDA is going to. What is their role? The purpose is to protect the policy holders. You cannot charge higher premium, right? Protect the charger, regulate the insurance industry. Then the objectives and responsibilities include ensure fair treatment of the policyholders, financial soundness, formulate standards, grant registration to insurance companies. In case of a company, you will incorporate under Companies Act. You want to do banking business, whom you have to go? RBA. Get a registration. In case if you want to do insurance business, go to IRDA, get a registration. So they provide registration, regulate the premiums for which the insurance is being issued, insurance cover is being given, provide grievance redressal for those areas is also covered by IRDA. Clear? Then there are other four small authorities. One, Pension Fund Regulatory and Development Authority of India, PFRDA, which is coming under the Provident Fund and Miscellaneous Provisions Act. What is their role? Pension fund. They are regulating pension funds. So the sole regulator of pension, including National Pension Scheme. NPS is nothing but National Pension Scheme. And they regulates custodian and trustee banks. Regulates the custodians of this pension funds. Whoever, how the pension fund works, we will be contributing. We will be saying that I would like to part of the pension fund. The employer would be contributing some funds to it. Post to your retirement, right? You will be receiving pensions for it. And there are schemes which this fund is going to be invested into. What are those? Is being completely governed by this PFRD. Right? The responsibilities conduct inquiries, increase public awareness onto the pension related matters, settle disputes between the employer, employees or relating to pension scheme, then register intermediaries between them, protect user interest, formulate the code of conduct for pension funds in India, right? Who are all involved under pension fund related activities, intermediaries, they give registration. They also give a code of conduct, how to perform this activity is being given. Then we have association of mutual funds. Mutual funds, you know, right? And all we will see. Mutual funds investments are subject to market risk. Please read the offer document carefully before investing. Right? They will be giving it in 5 seconds. Is that right? Not even 5 seconds. You know why they are giving it? Have you ever wondered? Why you are saying this? Not even I could hear it clearly. Why do you want to say? Law mandates it. There is a regulation under mutual funds which would say you have to give both in audio and visual form. You can see during this ad, they will also mention the text below. Also, right? Mutual fund, again, it is having a regulation under SEBI. Apart from that, they also have an association of mutual fund who says who are all the mutual fund intermediaries, AMCs, asset management companies. They are also to be following these common procedures. The self-regulatory non-profit organization for mutual fund industry development is their role. What do they do? The question can be, all this could be a directly, which says about the purpose they will ask. Dash is a self-regulatory non-profit organization for mutual fund industry. From the answer itself, question itself is giving you the answer, right? Mutual fund, right? Mutual fund would be the association of mutual funds in India, AMFI. Clear? So what is the role of them? Improve professional and ethical standards, spread awareness, ensure smooth functioning, and protect the investor himself. Investor whom? Mutual fund investors who are investing in mutual funds, not only stock market, they are also investors. Then we have Ministry of Companies Affairs, Corporate Affairs. These are the people who are going to handle companies as well as LLPs, registration, everything. So they are regulating the corporate sector and administering Companies Act 1956, 2013. Now it is only 2013, 1956 is all over, right? The goal is to protect the stakeholders, maintain competitive environment, regulations are being given. Complete regulations you have to conduct, you have to file your financials yearly once. All these things are regulations under the Companies Act. So that the regulator has the notice of what the company does. Clear? To protect the stakeholders, maintain competitive environment, facilitate company growth and development. All those are protective nature of them. Then NHB is the last one. NHB is what? National Housing Banks. They provide loan for specific to housing related things. So apex regulatory body for housing finance companies. You can see many companies, housing finance companies, right? They are being regulated by NHB. There are many value housing finance companies. You can see housing finance companies. So they are giving loans for the purpose of what? Building houses. For housing, they will give loans. Those housing finance companies cannot put their own rules and say that you have to follow this. They should also be regulated. How we are controlling the banks. Similarly, they are also providing finance. They should also be controlled. So this national housing finance is going to be the effect regulatory body for the housing finance companies. Then they promote housing finance institution and provide financial support and other support to whom? Not directly to the individuals. Through these companies, to this housing finance companies, they do. This housing finance companies, with the help of NHB, creates awareness as well as gives monetary assistance to housing financing for individuals and entities. Clear? Clear? Yes. So with that, we'll be completing part 1, which is lesson 1, introduction to the legal framework, right? Legislative framework. Clear? Any doubts? Good? Good. So we'll take a break. Time is 7:51. We'll come back by 8:05. Is that fine? 8:05. We'll come back by 8:05. We'll take a break. Yes. Back to the second chapter where obviously we are already aware of what is the percentage of marks, right? So the first chapter which we have seen is going to have 10% of mark, where basically 5% or all would be the marks which is there. Then second, which we are looking at, Contracts Act has the highest number of marks, which is 30. Is that right?
Yes.
Yes, 30. So 30. So how many questions? 15 questions. So this is the area where maximum number of questions is going to be asked from a single chapter. So again, in the same manner how we have brought into encapsulated format, the entire lesson of Contracts Act has already also been brought into the format of granulated and encapsulated. So we start with what is a contract generally, right? What is a contract? Which is agreement enforceable by law, right? So what is an agreement?
Offer process.
No, that is a promise.
Promise is a promise.
Very good. Promise or every set of promises forming a part of consideration thereof will be called as an agreement. Then agreement enforceable by law will come into a contract. So this is the same. They are going to ask what is a promise, you have to say offer plus agreement. What is an agreement of acceptance? What is an agreement? It is going to be every set of promises, very forming consideration of part, right? So basic concepts which is being already embedded. We'll see that. We'll start from that. Essentials of the contract will always have these two processes. For one is one offer, the one is acceptance. These two should there, and we are going to see anyways what is offer, how it constitutes an offer. So when offer present, the proposal present, offer is also called as proposal, assent is also called as acceptance. It becomes a promise, and every promise and every set of promises forming consideration for each other will be called as an agreement. Then the agreement would be contract when it becomes enforceable by law. Is that right? So when it becomes enforceable by law, we call it as an agreement. In case if it is not enforceable, what do you call it as? Void. Okay, void contracts are not enforceable by law. That is being given, right? So then, when it comes to promises, it is Reciprocal promise is also included. Reciprocal promise, you do, I do. So that is also reciprocal promises. Okay. So this is a very basic background where offer plus acceptance becomes a promise, promise and every set of promises becomes an agreement, agreement which enforceable by law becomes a contract, contract which is not enforceable by law will be called as void contract. Then what is a valid contract? Which is enforceable by law, right? Which is enforceable by law. That is one concept of enforceability, right? Enforce whatever we are saying is right, it is enforceable. What are the classes where it becomes unenforceable? So when you say it is invalid contract or a void contract, then what is valid has to be told somewhere, right? So where it is being told? Very good. Section 10 speaks about what are the essentials of a valid contract, which will be seen in the subsequent slides, right? So before that they are also speaking about what is an offer, what is an acceptance, which you generally see. What is an offer, what offer constitutes, right? So the definition of the offer is going to say about signifying some willingness to do or not to do. Willingness to do or not to do. Abstain is nothing from not to do something. You are going to make a proposal. I will not do this. Accordingly, you might have to pay. I will do this, so you might have to pay, right? Whatever it is. Or if I do this, will you be able to do this? That is making an offer. So the willingness to do or not to do something with a view to obtaining the assent. See, these two are many parts. I am going to signify my willingness is one part. Why I have to do that? With a view to obtain your consent, right? This view to obtaining your consent is also necessary. Otherwise, I am just making a statement. I would like to sell my mobile. Is it an offer? What is the question has to be added? Would you like to buy? Then you have an offer which is in place. Clear? Right? Good. What are the three characteristics of this offer? It should be clear, definite, complete, and final. Should be clear. Should give you complete information about it. It's final. Right? Not to be ambiguous or vague and not confusing. If I am keeping 3 mobile phones in my hand and saying that I would like to sell one of my phones, what is your next question? Which one of it? That should not be like this. I have to give clear information of what is it. It should not be vague. And it should be communicated to the offeree, which we know both acceptance and offer should be communicated. Otherwise, no point in it. I am having myself into an idea. Yes, I would like to sell my mobile. Not opening my mouth onto anybody. Automatically, the sale will happen. Only if I make an offer, you will accept. Right? It should be communicated. Then comes the category of a person who makes the proposal or offer is called the offeror. The person who receives it called it as the offeree. It can be in either more oral or writing or express or implied. What do you mean express? Express. Express words spoken or written. When it comes to implied, it is act or conduct, right? Even without speaking or agreeing in talking terms, we might also adopt a transaction that also allows us to enter into a contract. Boarding a bus, we know that the bus is going to go to Tinagar. That cases, I've already accepted the transaction to get into the bus, pay some amount and travel in it. It's a conduct. You're not going to go to the transport corporation, speak with them whether you will be able to take me to this class in this bus. Can you offer me a seat? No, we are not going to ask. Right? It can be expressed or implied. Then the offers can be of two types, which can be general or specific offer. When general to the word at large, by accepting or fulfilling the conditions, they may become the offeree. But in case of I'm making a specific offer, it is made to an individual or a set of people, and they are going to be the only person who can accept this offer. Right? What about the revocation? Revocation is cancellation. Revocation is cancellation. Whether you can cancel an offer, yes or no? Yes. Before the communication of an acceptance, you can do, but not afterwards is the language they would have used, right? So the acceptance is going to come, right? Once acceptance comes, what happens? The promise is already formed. So before acceptance is being communicated, Sir, he has mailed it, but I have not seen it. Can I say the acceptance has not happened? No, you cannot say that. From his point of view, it is already transited to you. You, if you are not seeing it, it is not his problem. The date on which is acceptance. Now we are looking at email contracts, all these things. Only for the purpose of revocation, we would be able to take an example of a letter which is being posted, and he has posted the letter on 22nd of November. The letter is going to reach on 25th to you. In the meanwhile, 23rd you want to cancel also, you cannot cancel because the acceptance has already left his hands, out of his control. Then you will still think that it is accepted as a promise, acceptance has been given, right? So when it has to happen, can be revoked before, any time before the communication of acceptance is complete or against the proposer, but not after the afterwards. You cannot do, right? So example which we would be generally taking is A proposes to sell letter by a letter, sending a proposal letter to the other person to sell house to B. B posts a letter of acceptance, right? A can revoke or at time where B posts this letter. They are not speaking about B's letter has to reach A. They are not waiting till that. Before B posts his letter, he has to be informed the offer is cancelled so that he will not write anything to us. They are not saying that B can write a letter, B's letter can come to A, and only at that time it becomes to the knowledge of A. Right? It becomes to the knowledge of A only at that point in time. But the intention to accept this is already raised as soon as the B posts his letter. That is the key criteria. Then, what about an acceptance? Similar provisions apply acceptance also with respect to revocation. Revocation. What is an acceptance in general? Acceptance. Offer your made willingness to do what to do. Acceptance must be. Sorry? You are going to agree. Acceptance is what accepting, that's all. Accepting whatever the offer made to you. You are going to a home, they are asking, would you like coffee? You have to say either you want coffee or not. No, I would like boost. What happens to the original offer? You are rejecting it. Rejecting and you are making a counter offer. Right? I'm just giving an example. But when it comes to an offer, when you are trying to willing to do or not to do, that has to be accepted absolute and unconditionally without posing a condition. I would like to sell my mobile for 20,000. You have to say yes or no. You are saying yes. Yes, I would be interested, but at a price of 15,000 only. Then it is not an acceptance, which is conditional. Make this consider. You are not giving an absolute thing, so it is not considered as an acceptance. Rather, it will be made as a counter offer. Right? Clear? So that is being clearly given under this part. When the person to whom the proposal is made signifies his assent, we call it as significant assent. We call it as acceptance. A proposal when accepted becomes a promise. Right? What are the key essential? It must be absolute and unqualified. You should not put up any condition. Matches the offer exactly. Communicated to the offeror. Obviously, to you, I have to say. Only then you will know. I'm thinking in my mind, yes, we should be buying it. You sold it to a third party. I'm coming and asking you how you can sell. You made an offer to me, no? So, this is that already I have clearly told you the timelines within which you have to confirm the offer. You didn't do. No, I was thinking of buying it. You can think for another 1 year, the goods have already been sold. So it has to be communicated to the offeror so that the promise gets formed. In case if it is a prescribed mode, it should be sent only in the prescribed mode and you have not sent it, the prescribed mode is necessarily important, or there is a reasonable time within which they have to reply. Obviously, if they are specifying within 10 days, the quotations and all, they will say you have to respond within 10 days. You are going on the 11th day, they will revise the prices. So no time is mentioned, sir. Then what will it take? Reasonable time. Right? I cannot come back to you and ask 15 years before you told you will be sending your car. Now I want that car. You will say that has already moved to various parts of India. right? So whether silence is an acceptance? No silence can be, because the silence is going to be taken into two parts. One is here under acceptance, the other one is under fraud. So here we have to accept this silence when it is coming to the acceptance. No mere silence can be accepted. Okay, because I am coming to offer you. Would you like to give have coffee? So you are all silent. I presume that okay, you are all agreed to have coffee. I'm ordering coffee. Silence can never be, mere silence cannot be an acceptance, right? You cannot write to a person making an offer, I would like to sell my mobile at 15,000. Please say whether you would like to buy it. If you don't reply by end of this week, I am going to construe it as you have accepted the offer and you have to pay. Can I say so? You cannot presume acceptance based on this category. Then what about an counter offer and counter offer which is being made by the other party? What is counter offer? As I told, you are not making it absolute or unconditional. You are putting up an question onto that. You are putting up a revision to it, saying that yes, I would like to buy it, but at 15,000, then it is not an offer being accepted, it is rather the offer being rejected. So counter offer amounts to rejection of the original offer and is basically a new offer which is made by the other person as an offeror. Now it is me to accept it or not, right? Conditional acceptance also amounts to rejection. What about a revocation in this matter of acceptance? I have told yes, I would like to buy. Later I find that my funds are being blocked. I'm going to come to you and say that sorry, I cannot buy it. Even though I have given my acceptance, I couldn't continue with this. What can we do? So the same way revocation is going to be taken up. Can be revoked anytime before the communication of acceptance is complete as against the acceptor, but not afterwards. Right? From my end, it has already been moved to you. So before it reaches to the other party, I have to come and say that no, there will be a letter coming. Please don't take it as I revoked it. Right? So before any time, if these acceptance as a proposal by a letter is being sent by a post, the same these acceptance is coming through post, right? So before it reaches A, B may revoke acceptance anytime there is letter or the moment it reaches before A is able to call him and say that or put a mail saying that there will be a letter and you don't accept it because I have revoked it now by way of this email, then revocation is possible. Clear? Clear? Any doubts here? Yes. Coming to one of the most important areas under contract law is section 10. Speaks about essentials of a valid contract. This is my viewpoint or the way it has to be made easier for you, where there are 6 elements which we are looking at. What are the 6 elements? 1. Offer and acceptance, which is resulting in a promise and an agreement. Offer and acceptance must be there. Then parties to be competent to contract. The object should be lawful, right, and not against the public policy. Right, object should be in lawful and should be in public policy, not illegal or opposed. Lawful consideration. Then capable of performance and enforceable by law. And the last one is free consent, out of their free consent. Right? As I always say, this is the area where you try to understand the difference between void and voidable. Easiest hack to understand void and voidable is to know the 6 elements of a valid contract and understand this in order, right? If you look at this first 5 things, offer, acceptance, competency of the parties, lawful object and public policy, lawful consideration, enforceability by law, and capability of performance. If any one of it is not there, sir, all these things are there, sir, but the purpose is against law. Can you do that? No, you cannot do. So, if any one of it or any of more than one of it is not being present, we call it as a void contract. Void contract. Clear? Clear? So, whenever there is a question, maybe possibilities of 1 or 2 questions which is going to end up like A and B entered into a contract for A promises to give an employment for which B has to pay a public employment. He is saying that I'll give you a government job, but you have to pay me 2000 as a bribe. You are requested to see what type of contract it is. Whether it is valid, void, voidable. Why? Opposed to the public policy or illegal. It's not lawful object itself, it's lawful. Right? So, that way you are going to the competency of the parties. A enters into a contract with a minor. Whether it is enforceable. What do you call this contract as? Why? A is entering into a contract with the other party to bring back 1950 some destroyed material back to life by magic. Why? For the reason impossible. Performance cannot be demanded, right? So he's bringing back means where any other ways it's different. By magic, can you do that? No. So reasons for why could be any of this. First 5 categories, if you find anything is lack, you will go for why. When it comes to the sixth point, where here only we are going to use our sixth sense, right? Free consent. What do you mean by consent? To agree on something. Free consent means what? Out of our own willingness. And we are also liking to be part of it. Right? So as we enter into this, it's out of free consent. I'm not holding you, right? For the classes. Is it your free consent or how? At least we have to say that it's free consent, right? We cannot say the truth. We'll say free consent. Right? Free consent is when both the parties has to enter into a contract out of their own willingness, as rightly said. Okay. Now, how you can say it is out of free consent? When these 5 elements are not being present, right? 1, 2, 3, 4 plus 1, 5. These elements are not being present. So what are those? So when it comes to free consent, coercion, undue influence, we are going to see that. Coercion, undue influence, fraud or misrepresentation are the cases where one of the party is getting affected. Right? One of the parties is getting affected. That makes the contract voidable. So here we are seeing the difference between void and voidable. Okay? So in case if it is free consent, the contract becomes voidable. A threatens B to enter into a contract. What is the contract? Voidable. It's voidable because one is out of coercion, it is being taken up. We'll see what is the coercion in the subsequent slides as well as a revision. And only one exception which is being given is under free consent, they are also speaking about the concept of mistake. In mistake alone, they are not going to take the contract to be voidable, it will be void. That is the only exception we have to remember. See, this is not something which section 10 is going to say about, see, these 5 are void, this is voidable, free consent, all this thing. They are only giving in the provisions for you to remember in such a way it doesn't confuse any question. Any point in time you have to identify whether the contract is voidable or void. You can just apply this rule and see what category it is falling in. Okay, first 5 categories it is void. Oh, sixth category, is it 4 or 1? Oh, that one mistake, then also it is void only. It is not falling under 1. It is something related to undue influence, then it is voidable. The most easiest way to identify between void and voidable is to remember in this way. Clear? Any doubts in it? Anyways, we are going to see all this part. So what the section 10 says is, when you have all the 6 things together, then you have a valid contract. Only then it is a valid contract. If not, cannot be enforceable. Clear? Good. Can you move forward? Yes. Now, this is just a very not so important slide, but we know already the types of contract can be differentiated on different manners. One is based on enforceability. When it is enforceable, it is called as valid contract. And it is enforceable by only one of the parties who is agreed party, then you call it as voidable when it is not enforceable at all, it is void. Unenforceable contract, where you can see this technical defects. If the question says a contract which is unenforceable, which is not able to be enforced for the purpose of technical defects, the word is mentioned. What do you have to choose? Unenforceable contract. It can be enforceable when, if the technical defect is removed, it can be enforceable. Then any contract which will have void ab initio or will not go under the public policy, there will be illegal contracts. Based on the enforceability, they are saying. Then based on the formation, you have formal contracts and simple contracts, where the simple contract is not so formal, or it is oral contracts which will come under the simple contracts. When it comes to the formal contracts, it depends on the law, where either contract which is done by under the seal, meaning contract is a written contract which is being done, or the court orders you to do something and you are obligated to do, then it is called quasi contracts and all. It's going to come under this category. So based on the formation, it is going to say whether you enter into a contract writing all the terms and conditions under which you are going to format, right, or by the court given order we are going to subject to be part of the contract, and accordingly the formation is going to be done based on the performance, right? When it is already been done, you call it as executed contracts. When it is going to be performed in future, we call it as executory in nature, right? Based on the obligation, how many parties are going to act on this contract? Either only one part needs to act, we call it as unilateral. Two party, bilateral. Multiple parties, multilateral, right? Then when it comes to the mode of creation, it can be express, implied, or e-contract. Express is where words spoken or written. This expert word alone, you try to remember. Anywhere when you use express, it is the same meaning. Implied, it is the same meaning, act or conduct of the parties. Apart from that, you can also now go for electronic contracts, which is purely signed by emails, right? E-commerce, email, all these things are going to be electronic contracts. Good. Very simple snapshot of it. We'll move to the next part. Then wager and contingent. This should be probably coming into the subsequent part of it. But since we are speaking about this void and voidable agreements, we'll see this and come back to it. Okay. So now we have, in the first part itself, we have seen about essentials of the valid contract, which is going to say about void or voidable or valid, these three categories. Specifically, they are insisting which is void, which is given under the law itself. You need not go and check the 6 elements. 6 elements we are checking, right? 6 elements of a valid contract. You need not go and check that 6. Instead, I am giving you an option where few are already, I am saying it is void. So that list is being given under this area, right? So basically, difference between void and void agreements is what? Void agreements are unenforceable, right? Not enforceable by law. Not enforceable by law, and the void at the very beginning, ab initio, we call it as void agreement. Unenforceable, we are saying. Here, voidable contracts are enforceable only at the option of one party. Who is this one party? Aggrieved party, right? But not by the other. So this person has the option to either accept the contract or resign the contract. Both are its option. Because he is the party who is going to be the affected one. Good. So that is the intention. So going by that, we know the differences between this and what are being specifically covered under Act itself is going to say these are void contracts. Don't even go check section 10. Not necessary, unnecessary work. I am even saying a list. So what are those lists? One minor is also going to be covered under the subsequent part. So I will not say that this is no way related to section 10. Section 10 also covers something, right? Competency of the parties. There is a duplicacy of the same thing here. Apart from that, there are also some other things. Okay. So we might see few things which is duplicate. I'll just mention to you because we are going to see it in the subsequent pages as well. When it comes to the void agreements, the list of considered which is being given as per our textbook, we can see minor or unsound person. Obviously, it is incompetent to party who cannot contract. it is void. Unlawful consideration. Lawful consideration is a valid essential. Unlawful consideration, where part of your consideration is unlawful. So there is a legal act which I am going to perform. Object is legal, but the consideration is illegal. Can it happen? Even then, your contract will become void. Bilateral mistake of fact. Anyways, in mistake we are going to see. Then also it becomes void. Unlawful in part. Either the here we are saying the unlawful consideration or object we are looking at. Sir, part is unlawful, sir. 50% is legal, 50% is illegal. This again void. No chance of the bifurcating this both the things and seeing okay, we will accept only the legal part. No, it's a part and parcel of it. So it can be so treated as void. So the example which we generally take the same given here. Let's assume I am going to import indigo and coloring dye from foreign country. I am importing indigo, which is allowed under the Indian law. I am also importing some illegal goods as a part of the shipment. There is only one ship coming. Under that, there is a shipment which has my name. It has 50% of indigo in it, 50% of illegal goods in it. Can I say that, okay, illegal goods alone you keep, legal goods alone I will say that it is valid? No, it is seen as a together. The objective is to do both the things at a time. Then I will be considering it as a, even in unlawful part, it is going to be called as void. Without consideration, any agreement without consideration is called void, because section 25 is going to say about no consideration, no contract. Exceptions are given. We will see those exceptions subsequently. Then they are speaking about 3 restraints. Restraints of marriage, restraint of trade, and restraint of legal proceedings, right? So what are those restraints is going to speak about? What are those restraints? Restraint means what? To stopping them from, to prohibit or even to stop them. Stop them is basically a very simple word, right? So to stop them from doing, can you do that by way of an agreement? Agreement and restraint of marriage. You cannot put up a condition or an agreement saying that one should not marry another person except for being minor. Obviously, minor cannot be married, right? So otherwise, you cannot put an imposition onto one person by way of a contract saying you should not marry them, which is void. Even if you have an agreement of that sort, it is void. Right? Then when it comes to restraint of trade, whether somebody can restrict you from, they would have mentioned that the section heading would be saying as trade. It also include say profession as well as business. Whether anybody can stop you from carrying on a lawful legal business, trade, or profession? No. If any contract is being entered into it, it is called void. There is only an exception. What is that? Goodwill. When there is a goodwill is sold, either the outgoing partner of a firm or the buyer of the goodwill might be restricting the seller of the goodwill, right? So either the existing partners or the buyer will be restricting the outgoing partner or the seller of it. Post to that, you should not use the goodwill for the purposes. So now we are going to put up a restriction on him to doing business under the same name. The reasonable restrictions will be allowed. So only exception for agreement and restraint of trade is as a part of a savings at the time of sale of a goodwill. The seller can be restricted from using it. An outgoing partner can be restricted from using it. Clear? Then restraint of legal proceedings. Can you enter into an agreement saying that you should not take any legal proceedings against me? That is also invalid. If at all you can do that, you can do only by way of or ADR. We say that first we will go to ADR, right? When there is a question relating to arbitration or an arbitration is being invoked now, or a bank guarantee which the bank would say that I would be honoring only the financial process if at all you have to have something, you cannot file a suit against me, you have to go against the original party. Then you call it as there is a restriction as to legal. Then uncertainty, there is no certainty because offer itself wants it to be certain. The contract has some uncertainty. Obviously, it cannot be enforced. It becomes void. Then wager only we are going to see next. Wager and impossible acts or events. Right? Wager is going to be seen separately. Let's stop it for now. Impossible acts or events. We are going to, because one of the 6 elements, fifth element said that enforceability by law and possibility of performance, both right. So possibility of performance is not now possible. You would have seen an example. A and B agrees to sell a horse. A wants to sell a horse to B, and unfortunately before the day of sale the horse dies. Whether on the next day a sale could be executed? No. So can they say no? Any way we have agreed, you have to bring the horse back to life and do it. Possibility is not there. Impossible performances cannot be enforced. The court even cannot enforce an impossible performance, so it is also void. Then when there is a reciprocal promises which is having illegal part, you will have multiple reciprocal promises. One of the parts is illegal also, it is illegal. So those are the provisions which is being saying about void and voidable agreements. Voidable agreements are predominantly going to be seen in where? Free consent. So you need not worry about it. Its act only provides the void ab initio agreements, which are going to be considered even without going to any other aspects. We will consider this as a void. Right? So before page we have to go where we have spoken about wagering and contingent contract. Why I have given it together is both is on some simple concept. The agreement is going to be based on what? Right? Agreement is going to be based on what? Future event. Uncertain future event. You have to see that, right? So it is uncertain. Uncertain future event is going to be taken up. So uncertain means what? Right? May or may not happen. And it is based on what? Luck? Probability? Luck, probability, everything. Yeah, obviously, it is in future. We will not be able to. It could be based on luck. It could be based on some event which is happening, which we don't have a controls in our hands. Right? So, law is going to consider one part to be valid, other part to be invalid. So, which they consider whenever it is based on luck, favor, gamble. India is going to win the match today. Today's match India will win. How much is the betting? It is going to rain this evening. Betting. All these are why? Because the ultimate aim is where? This money is the only reciprocation which you are taking. If, whether you are doing anything to the other party, no, you are just making a promise. If you do that, you have to pay. Or if it happens, I will pay. Apart from that, there is no individual event. There is no individual event. So it is clearly saying that wagering agreement will have agreement to pay money or money's worth. That is very important. To pay money or money's worth on pay from an uncertain future event. Right? There cannot be sued for recovery because it is void. They are not accepting the valid contract. For an example, bet of rupees 1 crore on a match outcome. The match is lost. Your friend asks you, give me 1 crore. Possible? Not possible at all. Right? There are exceptions like, this one exception which I am giving, horse winnings. There are other crossword puzzles which you win out of it, or any other provisions, lottery winnings to an extent. Those are all possible to be taken up. Right? So wagering cannot be enforced. You and I enter into a contract for a bet or relating to this, saying that if it happens, if it rains today evening, I will pay you. That is an wagering agreement, because there is no actual purpose which is possibly to happen. It is purely out of bid. Paying our money's worth as a bid. That is what we have to look at. Then the same sort of transaction is going to be taken into consideration, but only changes it is performance of a party is depending upon the uncertain future event. That event is going to be collateral. Collateral contract not to do or not to do something based on a collateral given. We call it as contingent contract, right? What do you think here? It is valid, it's enforceable. Where here it is also future based only. This is also future based only. But these, where in case it is going to be based on an uncertain event, you are going to make a common promise to pay monies or money's worth, uncertain future event which the parties doesn't have a control. Here also everything will be there. Only thing is there is no collateral event. What is the interest of the parties? You have to look at here. The interest of the parties is what? What is the interest of the party into this transaction? Only amounts, pay. What is the bid amount to receive this or not is going to be the interest. Here it is not that. It is basically some other event is there. On happening of that event, one party becomes money. What we look at insurance as an option. Right? Contract of insurance is a very good example of a contract of contingent contract, and certain other contracts also. When there is a very clear consideration between both the parties. I will pay you premium amount, you will be covering for my losses in case if an accident happens. If an accident happens, you are going to cover. If it doesn't happen, you will not cover. Based on happening of an uncertain future event, you need to perform. Clear? If it is not happening, you need not perform. Law accepts it, because the mere intent is to not to pay anything by this event at all. The event is collateral, a separate event. So they are considering it as a valid and enforceable. Wager is void, contingent is valid. 31. This is 30 and this is 31. Next to next they are giving. Okay, 31, and 31 says about how when it becomes for enforcement. At what point in time you have to enforce it is being given. 32, where if you are agreeing on event is happening, then you can enforce it when? Only when the event happens. Based on happening of an event, you can enforce it, means can only happen on an event. The agreement says so. The agreement says so, it will be payable. We will be covering you for the losses when the event happens, which accordingly. So 32 says that event happens, enforceable when if it is happens, and if it becomes impossible, it will become void. Clear? If it is can be enforced only at the time of happening of an event, and in case if it is going to be unenforceable, it becomes void. Then when it comes to event does not happen, if you have agreed that you will agree on a terms that event does not happen, I will be covering for your losses if event does not happen. Enforceable when the event becomes impossible. What examples which we generally take? If they say that the ship doesn't return within, right? If the ship doesn't receive within 1 year, I will pay you. Ship sinks on the third day itself. When you can enforce? Third day itself. Because you already know that the returning of the ship becomes impossible, right? So you have to make the differences to be very known. Event happens means event, if it is happening only, you will be the one to perform. So event happens when you can perform, only after the event happening. Before event you will not perform. So when event happen, I will have to perform. But the event becomes impossible, then it will void. If you have agreed that to perform when the event does not happen, you can perform as soon as the event becomes impossible also, right? Clear? Then what about this future conduct is involved of those parties? So it is deemed impossible if the person acts to prevent it. So 34 speaks about where there is a possibility of one of the parties will be able to control those events, and it is very clear that he might be able to control that event by his own this thing, and he may prevent that from happening, then possibly it will be impossible for them to go forward with the contract to be performed. Deemed impossible if person acts to prevent. So he says that after 1 year, I will be selling you this car. If I am still using this car, I will be selling it to you after 1 year. But 3 months itself, I have sold it to somebody. Whether the possibility of having the car after 1 year is there? No. Because that person has acted in a manner that the 1 year after contract becomes impossible to be performed. Then he need not check whether it is possible after 1 year to get this car. Now it is already a transaction has been done in 3 months. It becomes automatically impossible. We call it as deemed impossible. Then also you will not be able to do that. Why? Right? Then when it comes to a time specified for the purpose of this, then and that time is the key criteria. Void if time expires or the event becomes impossible. So the same example we are 33 we are looking at now. Same we can say instead of here we would be looking at if the shaft doesn't return within 1 year. The same example we are putting in a different time, saying if it is returning within 1 year, doesn't return within 1 year is the language which we use here. If it is returning within 1 year, I will pay. It doesn't return in 1 year or returns after 1 year and 1 month. Whether you are required to perform? No. The ship meets with the accident. What happens? The event of returning within 1 year becomes impossible. You will not be able to perform. So, void if the time expires or even becomes impossible. Clear? So, small differences you have to know between this. That's why the word keywords alone is added. Apart from that, 36 is going to say about already there is an impossible event, you are agreeing on that. There is no point in checking whether it is going to happen in future or not. Right? I'm going to clear all your papers by magic. Can I do that? Only you can do that. That magic who can do? Only you can do that magic. You can only clear your papers. I cannot do it. So, which to perform, I'm going to in future I may be able to bring back people into life, which cannot be possible. So it is why you have to look at that point in time, wait and understand whether it is possible or not. Now itself we are saying it is impossible, then it is why. So these contingent contracts are enforceable in happening of these events and unenforceable where certain aspects where the event becomes impossible or the event is at the time of entering itself is impossible, right? So both the things has common nature of happening of an uncertain future event, but the performance is going to be required only happen on the happening of that event. That event is to be collateral, then it will be accepted as contingent. There is no such collateral event. The only interest of the party is the money involved, then it will be wager and it will be void. In case of something else, you can follow the rules of contingent contract and see what is the purpose of the contract. Whether it is to be performing and the event happens, yes, you can perform. If the event becomes impossible, it becomes void. Right? If the event is not happening, that is what you have agreed. As soon as it becomes not happening, it will not happen, then it is becoming impossible to be void. Right? So all these things will be seen in the provision. Very least chances of specifically going into this 32 to 36 topics, but we have to know what if we are having a very good time for us. They might ask a one question in this also. Clear? Clear? Good? Yes. So we will stop here for a breakfast break and come back somewhere around 9:30. Yes, 9:30 we will be back. Good. So we are breaking for a breakfast break and we'll come back and see with the other essentials of the contract, which we already know by chance, but we'll just have a refresher about it. Yes. Resuming back to Contracts Act. we have seen essentials of the valid contracts. Until that, we have seen on the void and voidable agreements. Wagering and contingent, we have seen. We have to go forward with this. Sixth essential has been deeply discussed, and questions relating to that also is individually asked. So, even though when we say it is basically essentials of the contract, a minor contract is essential. It is an essential feature that you can only enter into a contract with a major. Section 10 does not say about it. Section 10 just says go and refer section 11 and 12, which speaks about the competency of the parties. So 10 itself covers the one-liner view of which is essential, but to know what is competency of the parties, because of the minor or major is not given in the section 10. They only speak about competency of the parties. Competency of the parties is being given under separate section 11 and 12, right? So that way, the elements of this section 10 is being given in elaborate manner in the respective sections. So we are going to see those. Few are elaborate, few are very simple. So we are going to see those in order to have a better understanding of it, right? So we are starting with consideration, which is one of the parts which we said section 25 speaks about no consideration, no contract. Is that right? That is what we are looking at, right? So no consideration, no contract is being given under 25, and they are also insisting on what type of consideration. What type of consideration? Is it lawful or unlawful? Right? Lawful consideration is being insisted by them. So what about the rules of consideration they are insisting here? Now, who has to decide the consideration? Who has to decide? I want to sell my mobile. Who will decide the price? I will be deciding the price. Okay, starting from where it is moving at the desire of the promisor. It must move from the desire of the promisor. Sometimes I may even ask you, what would the price you will be paying? So it may, from me it is must, from you it is may, right? That language they would have used. And what is basically a consideration? Something in return. That is what we are saying, that quid pro quo means something in return has to be reached by both the parties. Both the parties should have something. So that we call it as consideration. It says any act or subsistence promised at the desire of the promisors, essential for every contract. It is very essential for every contract which was taken up. Right? Who desires it? The promisor desires. And he does or abstains of promises, we call it as whatever it is being given. It is the consideration for the other party. I promise to do something, that is the consideration for you. You promise to do something, that is the consideration for me. Right? So where it has to be at the desire of promisor, may move from the promisee. Right? So to handle this, they are also insisting on whether in case if I am settling. We would have already seen a couple of examples on while we discuss in the chapter. Just to reiterate for the purpose of benefit of all. Let's assume I am taking my nephew to a shop and he is going to get some chocolates. The shop he is going to deliver to him. He is receiving the consideration. And for that, who has to pay? I need to pay. I will be paying the consideration to him. Will I be getting anything again? No, because the consideration which the shopkeeper has given to my nephew is already sufficient for what I am giving to him. So in those cases, not always the party, when he is doing it in favor of the other, will be always again receiving a consideration for himself. So that a case has been also given, whereas the mother, who is the donor, will give it to the donee, who is the daughter, saying that on a condition, I will transfer all the assets to you, but you have to take care of your uncle. Whatever the annuity payable I am paying now, you just have to pay your uncle, take care of him. The donee accepts it. Yes, I will take this as a consideration. You give me the property, I will take care of your brother, who is my uncle. But after that, she denies to do that and says that, why I have to pay to my uncle? What did he give to me? So the law says that not necessary that the uncle has to give anything to you. Your mother had made a promise, right? Whatever the consideration which is passed on from mother to you, it is enough for you to perform to the uncle or brother. So probably there is no necessity for a new consideration to arise on. Law took consideration which is from the mother to the daughter is enough for her to perform her obligations towards the uncle. Right? That is the case here, which we would have seen earlier. Now, the consideration again can be types of past, present, and future, which is already being completed, right? Or already being executed, and or maybe executed in future only. We are going to perform all these things possibly there. And very important section 25 speaks about these points. No consideration, no contract. There are few exceptions to this contract, this terminology, where there is no consideration, but still the contract is going to be taken as valid. What are those? Yes, these exemptions which is given below, because every exception has a condition to be fulfilled. In some nature, it is being taken up, right? So one is where there is a consideration falling out from one person to another, which is out of natural love and affection, which has to be registered and in writing. For an example, all this testamentary wills, they are writing, no? All these are what is the other person is going to get back? Nothing. Sir, no consideration. So it is not a valid contract, cannot be enforceable. Can we say so? No, because Act is considering it as an exception. So this is also will be taken into valid, even though in case of a property being vested on you by your grandfather and grandmother, right? Out of natural love and affection, they have put it into writing. It is happening between parties in near relation. Those four categories are the conditions to be fulfilled, where it will happen via near relation, it will be written and registered and will be happening out of natural love and affection. Then you call it as there is no necessity for from you to something pass on to the grandfather or grandmother, because it is made out of natural love and affection. Consideration might not be required. Then compensation for voluntary act. You have done some act voluntarily. You have identified somebody's lost person, gave it to them. They are awarding, they are promising to pay something to you. Okay, you have done some good deed. I am going to give you 100 rupees for that. They are promising something. Whether they can expect something again in return? No, it's a promise which you can be able to enforceable. Which act has already been done. Voluntary act has already been completed. In those cases, promise to compensate for voluntary act might not come as a consideration for the other party. Again, what you will do to him? You will receive the amount of 100 rupees as a gift or whatever the compensation which you have received. What you can give again? You have already give the purse. So for you gave the 100 rupees as a compensation for the purse, right? Now I am going to give something to you. Whether will we be doing anything? Not necessary. So he is even compensating for the voluntary act which is done by you. There is no necessity for you to again give any consideration onto that matter. Then time bar debt. What is a time bar debt? Promise to pay a time bar debt. What is it? Time bar means what? Time is already over, elapsed. So in case of a civil suit, how many years? 3 years, very good. So when it comes to 3 years has already elapsed, the other party has taken no action, or you are unable to find him and unable to take action. After all these years, whoever the person who took an 1 lakh loan from you appears after 5 years and you are going to ask him where is the 1 lakh. He says, promises that yes, I will pay you next week. And he gives a check or something or a promissory note in your favor. And he is asking, okay, I will give you a promissory note. What you will give me again? You will say that whatever you are giving me itself for 5 years owed you amount. What I should give? Please give immediately. So at the time of time or debt, a promise to pay a time or debt, it is already a debt which is due to you. You will not be expected to perform anything else. That is also an exception here. What about a creation of agency? Mere creation of an agency does not require consideration. I appoint you as an agent. I will not pay you anything. See, I am appointing you as an agent. You give me something. No, you do business. Probably I will pay you. Similarly, if there are expenses to be met by you, I will support for that. Just for you appointing you merely as an agent, I will not be paying anything. Consideration will not fall in. Appointing an agent is only an act of employing or making him for representing. Appointing him as an agent doesn't require any consideration to flow. Then, completed gifts which has been completed cannot be taken returned back in the nature of I have given you the gift, you didn't give treat. Consideration is not there. We will cancel the contract, I will restore my property which I have given to you. Can we do that? No, for completed gifts also it doesn't apply, because gifts again comes into the nature of an non-voluntary act, right? Sorry, voluntary act, not mandatory in nature. Nobody is asking, please give me gift. So, in case of a completed gift, you have given a gift to another person. Other person didn't give you anything. No consideration is there. Please give back the gift. Are you going to ask it? No, you know that it is a gift. There is no necessity for another person to give anything back to you. Right? That is also taken out. Contract of guarantee, where there are three people involved. One person is going to give you a surety over it, whether there is a necessity for a consideration to fall in. No necessity. That we'll be seeing again in the contract of guarantee. Then remission. What is remission? Lesser performance. Acceptance of a lesser performance is called remission. In case of a lesser performance is being accepted, will I be able to demand anything from the other party? I am accepting a lesser performance. No, give me something. So that is also not possible. So these are areas where exceptions is being falling in. These are contracts. These are contracts. All these are considered to be contracts, even though there is no consideration forming part of it. Law has recognized that these are areas where only one party is getting benefited. You all see this example, only one party might be getting benefited, or one only act has been performed. The other party might not receiving anything as a consideration, but still law would consider, because these are special cases where the contract can be enforceable. The contract establishes a relationship, but there is no necessity for the other party to compensate as a consideration. These are exceptions to the section 25, right? So general rules is already been seen here. Consideration shall move at the desire of the promisor, and it will be from the promisee or other person. Sometimes it could be act or existence. It can be past, present, and future. It shall be something of value. Something of value should be the consideration is something in return that should be of value, and it should not be unlawful. It should be lawful consideration, which we have insisted. Need not be adequate. This is the most different opinion which we are looking at. It need not be adequate as long as the parties. We are speaking about something of value, but it need not be adequate. Meaning what? Should be of valuable something, but equivalent value necessary? Yeah, not necessary. As long as the parties agree to accept it, we will be able to take it. For an example, I am buying something for, we are buying two juices, right? One is a very good one, which is costing 150. Other one is also expected to be very good, which is costing 200. But fortunately, 150 juice tastes better. Now we are saying that can we swap it? Okay, fine, no problem. This is one bottle of juice, that is the one bottle of juice. Now we are looking at, no, this is 150, that is 200. So we cannot swap it. Is there any condition? No. As long as you and me agree that we will transfer, it is of something in value, but not adequately compensated. As long as the party agree, not even the court will come into the category of seeing the adequacy of the consideration. Only place where the court will come into adequacy is where? When I force you to take it, where there is no free consent. There is a property which I am going to sell it, market value is 1 lakh. I am going to sell it at 80,000. I am agreeing, you are agreeing, you are buying it. Court will not ask it. But if in case I am going to make a complaint that the property is 1 lakh only, he or she is threatening me to sell it at 80,000, then the court will look into it, because when the free consent is affected, this adequacy might be checked. The adequacy of the consideration will be not be a matter. Inadequacy does not make agreement void if the party's consent is free. But if at all the party's consent is not free, the court may even look into this category. It should not be illusory, not opposed to the public policy, and it should not be pre-existing obligation which you needed to perform. All these things are consideration related. Clear? Then next is on the legality and capacity of the parties. We will see legality and capacity, then come back to privity. What is the legality of the object and consideration? We already know the object should be legal, consideration should be legal. Sir, partly illegal, sir. It is why. It is why. So, what do you mean call? What do you call that as illegal? We are calling it what is illegal. What are illegal? When you say it is illegal, it is forbidden by law. Law says that it is illegal, or it is defeats the provisions of the law. If you perform, it is going to defeat the provisions of the law. Then also you are going to call it as illegal. Or an act which is fraudulent, it is illegal. So they are just defining. We know illegal is a word. They are saying what are all illegal. How you define what is illegal? They start with if it is already forbidden by law. Law says that it is illegal, it is illegal. Or it is not said in the law expressly, but if you do that, it is illegal. Defeat the provisions of the law. For an example, you say that until 12 lakhs for a new provisions to come in. We say until 12 lakhs, you are exempted from income tax, for direct tax. I am selling an example. Now, what you are trying to do, in order to bring into this provision, you are earning more than 12 lakhs, but you are going to bifurcate it and say that there will be different entities which will be having, I will be billing from 4 different entities, so that all the entities or the individuals, I might employ 4 people, and all 4 people will be earning only, I will be billing in their name. What is the purpose here? To avoid tax. If I am going to bill 48 lakhs in my name, you will be putting me tax. So what I am doing is, I am going to put in 4 employees under me. Okay, I will bill under their name, so that the income shall be recorded in their name. I will try to find another way to get it back from them. All these things are instituted. Law has something relating to specifically saying that is illegal. No, they might not say it, but the action, it is going to render the law to be useless in this case. So, which defeat the provisions of the law, then also I will be considering it as illegal. So, for an example, tax evasion is being seen here. Then, when it's fraudulent, right, which is fraudulent, to deceive somebody, the promise itself is to deceive you, then it is fraudulent in nature. Deceive means what? Cheat. Deceive is to cheat somebody. Even then in case, it will be called as an illegal. Involves injury to another person, physical or property. Individually, you are going to be injured, or your property is going to be injured. Any contract for the purpose of that to be entered will be considered as illegal. Anyways, that is also forbidden by law in certain areas. The criminal acts are going to say that it is forbidden. Then, immoral or against the public policy, then also you will be trading with the public enemy, all sort of things will be called as immoral and failing the public policy. This is where one information I want to give you. So we know this is void. By directly it is void. In some places, the question is going to not only lay void as an answer, they will say void due to public policy. In those cases, you may select void due to public policy, and they will not be having 2 options like void due to public policy. So void due to public policy, the only answer would be there. You need not have a doubt saying that, sir, we didn't say something like this. Void due to public policy, nature of void. Okay, you can definitely go and select it. It will be provided. Need not get a doubt, sir. We are as of now we will see only void, voidable, valid. Void due to public policy we didn't see any provision as such. This is the meaning. Void, what is the reason how it becomes void? because of it is opposing to the public policy, it become void. So you can always take that answer as a void due to public policy, right? Then what is the consequence of it? We have seen void agreement. For an example, A promises to get a public job for money. We pays rupees 1,000 for that. What happens? This is against the public policy. It is not an legal thing to do. Right? A government job by bribing is not a legal thing. So we are considering it as void. Clear? Then coming to the capacity of the parties, other category, which here itself we are covering two. The first page we have already covered, one consideration, three is already getting covered. Right? The fourth one is going to be capacity of the parties. What do you mean by capacity? They can enter into a contract. They are basically making it into very thin line of three things. One is the age of majority. Two, sound mind. Three, not disqualified by law. So that is also they are elaborating. So what do you mean by majority? It's very simple. A person who is above the age of 18 or 21, 18 under Indian Majority Act and 21 under Guardians and Vans Act, 21 is the age. So if the person who has not completed that, they will not be eligible to enter into a contract. Okay, so what if they can be admitted into partnership as a beneficiary? That can be done. Only then they cannot become a partner. Can be admitted to the beneficiary of a partnership firm. Whether they can be personally held liable. So one line we have to remember is any contract which is involving a party, they cannot be personally held liable. So the void nature applies there. You cannot make a minor to be a partner of an agreement because it is considered as void ab initio, means void from the very beginning. There is no way you can bring in a minor as a partner, minor as a party to a contract. Clear? Because there is no way you can make him liable, personally liable. So agreement with a minor is a void ab initio, meaning void from very beginning. No estoppel. What is estoppel? Pretending. A person who is pretending to be a major, he enters into a contract, and later he says that reveals that he is a minor. Can he escape the provisions? Yeah, unfortunately, law is allowing that yes, you can escape the provisions. Right? So they say that principle of estoppel, pretending cannot deny later, may not be applicable to the minor. So that is the only exception which minor has, not no other person. Even for a partner, for other cases, the agent who is acting as an agent as estoppel, by way of estoppel, they cannot deny the fact later. The principle allowing somebody else to act as the agent of them by way of an estoppel. Later they cannot deny the fact that they are agent because they have accepted them to be represented as an agent. Then they cannot go back and say he is not my agent, which is not be accepted. But here alone, the principle of estoppel does not apply to a minor. They are insisting the no estoppel can be applied. No restitution means what? Restitution means what? Restoration of property. You cannot impose them to restore the property. No ratification. After he enters into age of 18 or 21, whether automatically becomes valid. I entered into a contract with a person when he is 17. Soon after 18 years have happened. Now I'm saying that okay, at the time it was not valid. No, now he has attained 18. Can it be valid? No, there is no automatic ratification. Even in the partnership act, they are giving some provisions. So you cannot say entered into 17, which is void at that time. Now it is 18. No, now I will enforce the same contract because it is valid. They will say that at the time of entering itself, it is void. You cannot continue this contract. So no ratification is also possible. Whether they can be appointed as a beneficiary to the contract, yes, they can be appointed to a beneficiary. They can even enforce those beneficiary contract in the benefit of the guardian. Agent, they can be agent, but they cannot be made personally liable. Necessary liabilities is there. Somebody has provided necessaries to the minor. Can they recover? Personally, they cannot enforce on them, but there is a property of the neighbor, they can enforce on it. and they cannot be insolvent, right? Obviously, they cannot enter into a contract. Obviously, they will not be declared as insolvent. Then, second point is where? Unsound mind. What do you mean by unsound mind? We have to see who's sound mind. Who will be calling as sound mind? Very good. Capable of understanding is point 1. 2. Based on what? Based on capable of understanding, what you are going to do? Rational judgment. Come up with a decision which is rational, involving your interest. So that you have to see. A capable of understanding and rational judgment should be there for a person of sound mind. But in case if you are going to be incapable of doing that, then probably you are not of sound mind. It's an unsound mind, right? So whether you can enter into a contract, the law prohibits you don't have a capacity to enter into a contract. Then we have occasional soundness, occasional unsoundness. So there would be in a language saying that a person who is generally of unsound mind occasionally gets sound. Can he enter into a contract whenever he is sound? Absolutely yes. Whenever he is sound, he can do. There is another person who is generally of sound, right? Occasionally he gets unsound. Whether he can enter into a contract at that point in time, when he is sound, he can enter. When he is unsound, he cannot enter. A person who is in drunkenness, he is generally a sound person, but during his drunkenness, can he enter into a contract? No. When he is out of this delirium or drunkenness, he will be able to do. Right? So that he can say the patient, when in case of a lucid intervals, when he is back to sound mind, he can still enter into a contract, but in other cases, he cannot do. Just give me a minute. Yes. When in case of a patient who is having a lucid interval, when he come back, a lunatic person who is coming back to a normalcy, which is having a sound mind, can still enter into a contract, right? So that is acceptable. Apart from that, a person who is under generally of sound mind, who is a drunk or delirious in fever, so those persons who cannot enter into a contract, while at the time of unsoundness, subsequently they can still resume to be a person. Once they are back out of this, they will still be able to enter into a contract. Apart from that, the law gives prohibitions or disqualifications to certain parties who cannot enter into a contract. That includes a person who is of insolvent in nature. He is already convicted of an offense. So we have seen a few people. So alien enemy, whether you can enter into a contract with the alien enemy? No, it is not possible. Insolvents not possible. Foreign sovereign or ambassadors, they are considered to be under the Foreign Governance Acts. They are only a representative here. I might not be able to enter into a contract with them directly because they are governed that they shall not enter into a contract. So if at all they want to enter into a contract, only through agents they can enter. Very good. Then corporate bodies, unless they are MOA, Memorandum of Association and Articles of Association permit them to enter into contracts, only then they will be able to enter into a contract. If your memorandum of association, in case of a company, if it doesn't have a clause saying that to enter into contracts, it doesn't have a clause, probably you have been restricted. Then you have to go to the members and say that whether we can enter into a contract, they approve, we can go and enter into a contract. Then convicts of imprisonment, right? Convicts who is undergoing imprisonment cannot enter into a contract. Convicts undergoing imprisonment cannot enter a contract. After they are back from imprisonment, can they enter? Absolutely, they can enter. Okay, the law only says convicts undergoing imprisonment during their jail time, sentence period, they cannot do. After that, they are not speaking about any subsequent disqualification. Because why I am mentioning this, there are few places in case of a directorship or some other provisions, when you see in your subsequent intermediate subjects, they will say 5 years they are disqualified, meaning the conviction has already happened. He has gone to jail and come back. But still, for the next 5 years, there is a cooling period which he cannot be appointed. Disqualification still applies. But here, for convicts, they are only simply saying that for contracts during the conviction or the imprisonment period, they cannot enter subsequently. Intoxicated persons, they are unto substance, they cannot enter into a contract. That is also taken into consideration. So the capacity of the parties says about who can enter into a contract, who cannot enter into a contract, basically into these three categories, which is absolutely necessity to know, right? Then apart from this, I'm just also adding doctrine here itself because it's relating to that, where what is strong doctrine of privity? Privity means what? Private in nature. You and me agreed it's private in nature. So if at all somebody has to raise a suit for your non-performance, it should be whom? Me. If I am not performing, who should ask? You, not any other person, right? So in that way, it is very clear that parties to the contract can alone sue, not a third party. No stranger, a stranger cannot sue the under a contract. Okay, there are few exceptions to it, where in case of a family settlement, trust, where the beneficiary is going to be another person. Let's assume the father is writing a will onto, there are three sons, out of which only on one son he is making the contract. Between both of them, it is a contract, right? But the problem is he is giving all the property to his first son, not giving anything to second and third sons. The second and third sons feel it to be undue, right? It is wrong. Then they are approaching the court, right? Whether they can say, no, the privacy of the contract is not there. No, there are exceptions where they are going to get affected because of this contract. So exceptions is being given. In general, no stranger or a third person can go between two parties into a contract for suing, cannot sue. That if at all, it is exceptions exist where with respect to trust or family settlement, there are few other things. Beneficiary of a trust is an example here. Family settlements, there are a couple of settlements where in case of an agent which he may be authorized to do so, all those things is also family member. In case of death of an individual person, insurance contract is to be taken. Who will be taking it? The insurance contract, and the person insured is the person who is entering into a contract. Now insured has already died. Who will come and claim? Only the family members. Can the insurance company say, no, we didn't enter into a contract with you, we entered only with your husband, come back with him, I will allot you the amount. There is no possibility. So those are exceptions which will be seen into privacy where the exemptions are being provided. Clear? Clear? Can you move forward? Yes. Good. Then after section 10, the other important area which is for free consent. So free consent should be there in a contract means what? Out of willingness, right? What it refers to, flaw in consent is being given here. Okay, here we are saying when consent is not, this basically means when you have a flaw in consent, right? Flaw in consent, we are going to look at this. These are flaws. So starting from what is the consent, two or more persons agree upon the same thing in the same sense. It is called consensus ad idem. There is a word where both of our senses are thinking about in the same manner. We call it as consensus ad idem. Okay, this is for only for consent. Consent is both the parties thinking about the same mind. But how? You are having a different mind, but I am pushing you to think about in the same way means I am going to threaten you. You should also think like that. Then it is not free consent. There is consent, but it is not free consent. So moving on to this free consent part, they say consent is free when they do not employ any of these things. To obtain your consent, I am not doing any of these things. Then you call it as free consent, right? So it starts from coercion. Coercion is what? These are the keywords. Whatever the first level of things is there, it is keywords. So probably if you have to remember this, then we know what is the type of flaw in consent we are looking at. Because the person may say any one of this. They say A threatens B to enter into a contract. The contract can be avoided if it is going to be under the category of what? Either coercion, undue influence, fraud, or misrepresentation. coercion, because the nature of this is threatening, right? So that is being given differentiated for every individual type of. So we have to look at it. It starts from coercion where committing or threatening to commit. Either you are committing or threatening to commit an act forbidden by Act IPC. Now, anyways, you have to look at BNS, right? BNS is or unlawful detaining of a property to compel an agreement, right? So I'm doing any of this act to pull you into an agreement, to push you to enter into an agreement, or induce you to have an agreement with me by threatening you or committing something. So all these things would be considered as coercion, right? So there are cases where, in case if it is going to be a threat to suicide, whether it would be considered threat to suicide. Yes, it is forbidden by law. Threat suicide is not forbidden by law. It's forbidden law. So obviously it will be considered to be an coercion. Somebody says that you have to enter into this agreement, business agreement with me. Let's assume you are sitting in a manager of a bank or something. Somebody comes in, sir, if you don't, he comes in with a very neatly dressed suit and comes and sit before you. He proposes as a loan agreement is there. You have to give me loan. You say, well, how can I give you loan? No, if you don't give me, I will suicide here itself. Can you make you enter into a contract in that way? No, obviously you are not a person who is going to allow this to happen, right? So he is threatening you to enter into a contract, a loan contract or whatever it is, by forcing you to enter into this. How is he threatening you? I'll commit suicide or otherwise. So pure act of coercion. But there are other cases where a mere threat to prosecute or charge high interest or high prices, it's not coercion, because I might be saying that if you are not confirming your order within today, tomorrow the prices may go up. I'm not threatening you to enter into a contract. I'm just giving you the consequences of it. It is not that way. You are not returning my funds. Then I have to file a suit. Whether this is threat? Yes, this is a threat. Whether it is a coercion? No, because what I'm taking it is not illegal under the law. What we have to look at in this, identifying what is the special case or not, is you have to see whether it is forbidden by law. It is not forbidden by law, then it is not coercion. If it is forbidden by law, the act which we are proposing is forbidden by law, it is absolutely coercion. Clear? Then coming to the undue influence category. Here also there are two keywords. What do you have this? Domination, right? Dominant position, and not only dominant position. Now I have a dominant position all over you. Yes, absolutely I have a dominant position. But whether I am unfairly taking advantage decides whether I am in undue influence or not. So it defines two aspects: domination of will to obtain unfair advantage. So the domination should also be there. The unfair advantage should also be there. It could be real apparent authority or a fiduciary authority, whatever it is, but both should be present. Mere dominant position is not called as an undue influence. The dominant position making you a decision to enter into a contract by which the other party is going to take an undue influence is called undue influence, right? So unfair advantage should also be present. That is what insisted. Let's assume a person who is entering into a contract with his son who just completed his college. He is saying that anyways you are in my control only. I'm going to lend you a loan of rupees 1 lakh, but you would have to pay me back as 20 lakhs. So can it be possible? Under his undue influence, he is taking back an unfair advantage. So dominant position is also there, unfair advantage is also there. So we cannot call it as a free consent, right? It's an undue influence. Because of that only he had to enter into a contract. Both should be there. That is the insistence. Everywhere we can see undue influence. Part of it undue influence. Domination will be there everywhere, but unfair advantage might not be seen. So only when the dominant position is used to take an unfair advantage, I will consider it as an undue influence. The presumptions between parent, child, guardian, ward, doctor, patient, where they have a position and they are also trying to unduly influence them, unfair advantage is being taken from them, then you call it as undue influence. Otherwise, not. There are no presumption between landlord and tenant, right? Debtor and creditor, husband and wife, unless Kardashian housewife may not be. Kardashian housewife is basically they can only speak to their husbands. There is a dependency created. In general, you cannot say that if they are under the control. But here they have to, for even for their basic needs, they have to approach them. Then we might say that even for the basic necessities, this husband has to support her. Otherwise, she will not be able to do that. There he may exercise an unfair advantage. But otherwise, between these people, there is no presumption. Here, there is always presumption of domination. Now, we are only speaking about domination. When we say this real apparent authority or fiduciarily affecting the mental capacity, all these things are only understanding, trying to what is the dominant position between people. These are dominant positions by nature, these are not dominant position. But both the cases, we have to see whether the dominant position party is trying to take any unfair advantage from the other party. Only then you will be deciding whether it is undue influence. Clear? Then, when it comes to this fraud and misrepresentation, the very thin line of difference. Fraud is what? Intentional. Intention to deceive the other party is there. But in case if it is unintentional, yes, it's misrepresentation. That we have to just understand, where the person who believes it to be untrue. I know that it is false information, but still I tell you that it is true, 100% verified. Then I am doing fraud. Right? Sometimes I might have not the complete information. I failed to go back to verify the authenticity of the information, but still believe it to be true and making it representing before you, which is unintentional and not any reason. Innocently I am doing. I believed it to be true and said that. Then it is misrepresentation. But for the other party, both are going to be at loss only. If I am knowingly cheating you or unknowingly cheating you, you are cheated. For you, it is same. You can still go against me as same fraud, whatever you are going to come against me, undue influence also you can come against me. No problem. Right? Now, under fraud, we are also speaking about silence. Mere acceptance can be a silence. Silence can be an acceptance. Sorry. Mere silence cannot be an acceptance. Right? Here they are asking whether mere silence is a fraud. No. When it becomes a fraud?
When there is duty to speak.
Ah,
When silence is ignorance.
very good, very good. When there is a duty to speak and you are not spoken, right? Or the silence itself equivalent to speech, then it will be considered as a fraud. Good. So all these four elements which we are looking at are in nature of voidable nature, because one of the parties is getting aggrieved. They can only, the voidable definition would say that only one party can enforce the contract. Valid contracts where? Valid contracts both parties can enforce. Void contract cannot be enforced at all. Voidable is somewhere in between this, where only one party can enforce, not the other party. Who is that one party? Is the aggrieved party. The aggrieved party we able to. Here, all these four cases, there is an aggrieved party, right? A person who is entering into a contract under coercion is being threatened. He is not out entering into a contract without free will. He is being under coercion. Undue influence. Due to this dominant person's influence, he is entering into it. Then also he is aggrieved. Fraud or misrepresentation. A person based on a fact which you have fraudly or misrepresented, I have entered into a contract. Now I am being at loss. So I am the aggrieved party. If these people think they can have an option to enforce the contract, to declare it as voidable, right? So in those cases, they have an option one. In case if they choose to cancel the contract, what we call it as rescinding of the contract, right? Contract of rescinding is what? Nothing but revocation. All these things are same meaning. Revocation is cancellation. Rescinding is cancellation. So they can choose to resign the contract. In case if they choose to resign the contract, what happens? They have to, very good, restore the benefits if anything they have received. I'm going to sell a product which is not even worth of 100 rupees, 2000. You go back home and your father or mother scolds you, "Oh, you bought this for 1000. Go and return it. Cancel the contract." So you come back to me, sir, I'm cancelling the contract. My father or mother told this need not be part of rupees 1000. Okay, what is the next thing you have to do? You have to restore that product to me. Otherwise, you cannot say you are rescinding. You can resign the contract. If at all anything has passed on already to you, the benefit should be restored. You cannot have both ways. Here you would have seen example. Let's assume there is a book which is in market it is 100 rupees. Now here I am selling it at 500. Subsequently, you identify it and you come and say that I don't want the book. Right? What you have to do? You have to return the book and cancel the contract. You cannot have the book and cancel the contract. Right? So, effect of this is agreement is voidable at the option of the agreed party. They can resign the contract. In case rescinded, they have to restore the thing. Restore any benefits if received only. If not received, not a problem. If already received, you have to return it. Then, when it comes to mistake, why we are seeing this mistake as separately? Because mistake is going to make the contract void. Right? Mistake can be of two types: mistake of law or mistake of fact. Mistake of law is law of the country or the foreign country. You are not aware of the law of the country, or not aware of the law of the foreign country. Either cases will not be able to go forward with the contract. There is a mistake in the nature of the contract, law which binds the contract. We don't know that is illegal in India, but still we enter into a contract. Whether it will make it validly acceptable, both the parties accept. We promise that we don't know, otherwise we will not admit. This time alone, please allow us to smuggle these goods. Will they allow? No. Innocence can be accepted, but ignorance of law cannot be accepted. So ignorance of law cannot be accepted. So even in case if it is out of Indian law or in foreign law, it is not acceptable. Then when it comes to mistake of fact, mistake of fact is the subject matter. Mistake of fact is nothing but the subject matter or possibility of the performance of the person. In case of the subject matter, there are 6 elements which we will be looking at. One is both the parties, there will be bilateral and unilateral mistake. So in case of a bilateral mistake, there can be either relating to subject matter when it comes to 5 elements. One is existence, right? Identity of it, price, quantity, quality and title. All these categories could be considered. And in case of impossibility of the performance, whether it is possible to be performed or impossible to be performed. So 2 aspects are there: possible by physically impossible or legal impossibility. Both these things would be taken into consideration. If it is not possible, then it is becoming void. Bilaterally, both the parties has this problem. So subject matter is being considered for 2 categories. Both the parties has the problem in understanding it. Is it right or not? Clear? Clear? So both the parties having it is bilateral. In the subject matter, both the parties are not aware of the 6 aspects. What are it? Existence, identity, title, quality, quantity, price. Both the parties have a wrong understanding bilaterally on the subject matter. Void. Impossibility of the performance or possibility of the performance. Both the parties are not sure about the physical possibility of the performance or legal possibility of performance. Both the cases it becomes void. Unilaterally, if only one party has the wrong idea, even then he will be entering into a contract with the lesser perspective. So even then it is being declared as void. Okay, clear? Then as whole you can see that out of 3 concerned, they are dividing into 4 plus 1. 4 is predominantly into voidable and mistake is going to be taken into void. That is the key change which you have to remember, because first and section 10 we have told that first 5 are void, 6th one is voidable. Now we are saying under sixth one there are 5 things. 4 plus 1. First 4 are voidable. Last one is y. Mistake is y. Clear? Any doubt here? Can you move forward? Yes. Then what is quasi contracts? Right? Law enforces
Obligation.
yes, law enforces the obligation. How? What is the difference between a normal contract and a quasi contract? What essential elements will not be there? Illegal things you will have in quasi contract? No. What? You are right. Tell me. You are right. You started. Offer acceptance will not be there because it is law imposed. The act has already been done. There is no offer acceptance will initiate the contract, but the contract is being already formed by the law, imposed by law. Clear? So quasi contracts are contracts which is not created by offer or acceptance, but the law imposes the obligation onto one party and the right to claim the performance by the other party. We call it as quasi contracts. So obligations are implied by law where no offer, no acceptance, no consensus added up, but still the court recognizes relations resembling to contracts, right? Contracts, and to prevent unjust enrichments. One party is getting a benefit which he is wrongfully attaining it, then he has to restore the benefits to the original party who is supposed to have the benefits. For an example, we see neighbor consumed mistakenly, right, delivered food. What he is supposed to do? He has to restore the benefits to the neighbor who is supposed to actually receive it. If he fails to do that, the other party always claim his right from the other party. He has also an obligation to restore it to him. So, bound to replenish. Replenish means restoring this, replenishing the unjust benefit to the original orderer is to be taken. What is the differences between contract and quasi-contract? We can see basis. It's agreement and promise. It is formed through offer and acceptance. Here, it is not. It is imposed by law or justice. Elements, offer, acceptance, consensus will be there. No, it is a legal fiction. How it creates. Legally, it is created. Nature, it's voluntary of rights and obligations. It's involuntary. We don't want to enter into a contract of quasi contract. It is imposed on us. So it is involuntary and courts infers the relations. What are the types of quasi contract is being seen between 68 to 72? All are like stories. A person you have provided necessaries to an incapable person, the other person has to restore because you have given something out of your own will, right? So reimbursement from the property of an incapable person or necessaries supplied to them will be considered. So not only here it is incapable person includes a lunatic, minor also you can look at. Minor also you can claim against the property, right? Same. So there is an obligation. If they are not paying you, what you can do? Go to the court and ask, I have met their expenses. You have to pay me. They are also obligated. The property of the minor can be brought into this for because you earned money and you spent on this minor or a lunatic person to safeguard him. Now you have the right to get yourself replenished on those costs. Then reimbursement of money paid and debt of another person is being paid by you. What you can demand from the original person who has to pay? The same amount. You can ask him. Your friend's debt you have paid. What you can ask your friend? Say, instead of you, I have paid your debt. Please give me back. He says, did I say you to do? No, I will not pay. Can he say that? No. He is bound to perform towards you. And you also have the right to do that. So, person interested in payment, which another is bound by law to pay, is entitled to reimbursement. Is also covered. It is all quasi-contract. We never said, the friend didn't say that any time in future, if somebody comes and say my name and asks you to pay, you pay. Later I will pay. Is there any agreement in the earlier? No offer, no acceptance, no consensus. Since it has been done, they are taking into consideration. Then any non-gratuitous act. Non-gratuitous means what? Gratuitous means expecting without expecting anything. Gratuitous means without expecting anything. Non-gratuitous means I am expecting something to be done. I'm sharing a product with you. What is your obligation? To return it, to restore it whenever you have it. Right? I'm giving you a product. You didn't bring something which is very necessary. You used one of my product. I had an excess, I gave it to you. What is your obligation? To return it. You buy new one and give it to me. Because I didn't give it to in a gracious manner, non-gracious way. Okay. I lent my raincoat to you. Today you can reach home safely. And you are keeping it for yourself. Can you do that? No, you have to bring it back to me. You have to give a consideration for that purposes in case if I am not going to give you. Let's assume I am having an umbrella. Okay, I'm just going to rent it out. 1 rupee until you go to the car or go to your vehicle, you can access to it. Then if it is, I'm doing it a non-gratuitous act, what you have to do? You have to pay, right? If it is any sort of thing which is clearly mentioned as non-gratuitous, whether an agreement is there or not, you will have a imposition of an obligation onto one and right onto the other will be taken into consideration. Then finder of the goods as finder of the goods, what his obligation is to give back to whom? Owner. The original owner comes back and asks for the goods. What is your obligation to do it? Whether he has the right to claim it back? Absolutely, he is the owner. So whether we have agreed somewhere with the owner, anytime you lose your goods in the road, if I pick it, I will return to you. Whether we have agreed that way? Not possible. So no offer, no acceptance, but still the right is being imposed. Let's assume there is a watch of yours, you lost it somewhere. By some chance, I took it. I was using your watch. You later identified this and asked me, this is my watch. This is a unique watch. I know that it is also engraved my initials. Please give it back to me. I say that no, I will not give it. It is not your watch. Right? But we know that it is his watch, but he is not going to get it from me. What he can do, if he is going to sue me, I am obligated to give it back to him. Even though I am a person who acquired it somebody else, not a problem, or I took it from the road, what is my obligation? To return it to the original owner, it is when he is asking for. There is no written law that I can own it. It has to be restored. So he has the right against me. I have an obligation to return it to him. So the finder of the lost goods has the same responsibility as the bailee. Who is the bailee? Bailee. Bailor, bailee, bailment of goods. Subsequent special contracts will be seeing a person who is receiving the goods for some purpose has to return the goods after the purpose has been accomplished. Until such time, what he has to do? Keep the safe custody of the goods, right? So similarly, it is insisting on same as that person, the finder of the lost goods should be taking care of the custody of the goods which he has picked up until the original owner claims it back. Right? Under the last category, a payment which is being given as a mistake or through coercion has to be returned back. I am threatening you to get an amount back. Subsequently, you have the right to claim it back. I am, without your permission, threatening you and taking your mobiles. You can take it back, claiming that you have the right to take it back because I have an obligation to return it to you because it is your mobile. Or I am delivering the cash which I have to pay to you. Instead of you, I am delivering it to your brother or sister. What right do you have against them? To claim that amounts from them. Right? To claim the amounts from them. They cannot say, no, I cannot give it to you. Can they say that? I very clearly say that please hand it over to your brother or sister. I have given it to them. Then they have an obligation towards you to restore that amount to you. You have a right to claim from them. All these things are quasi-contract. So, these 5 types of contracts where nowhere the parties has an offer or acceptance to carry out this. Generally, how a contract gets created between the consensus of the parties, offer acceptance will be there, and they will agree on this is your right, this is your obligation. Or for each party, they will say, but here is that works that way? No, agreement is not there. Nobody is fixing the rights and obligation. Who fixes that? The law imposes the rights and obligations. Then you call it as quasi-contract. Clear? Any doubts? Right? We'll take a small break, come back for the others. Right? Good? Is resuming back. The next topic is on performance of the contract. What is performance meaning? Performance of a contract. You have promised to do something. When you do it actually, we call it as a performance. When it has to be done, whether it has any conditions to be fulfilled at the time of performance, say it has to be performed at a specific time, and who should perform, all these things are given under the performance of the contract. So in simple, we have looked at two certain topics. One is whether performance is required or an offer to performance itself is enough. What do you think? Performance is required. You are ready to perform. The other party is not accepting it. Whether they can say later you didn't perform. Somebody is not allowing into their home and say that you don't visit us often. You don't even visit us. When you visit them, they lock their doors. Can they say so? You are not visiting us. What do you say? Every time I come, you are not available to your home. You are locked. Then how can you say that I am not visited? Right? So, where the obligations of the party starts from where the performance or offer to perform is being there, then also it is being considered as performance. Because later when it comes to the discharge of the contracts, they will say not only actual performance, also attempted performance will be taken into consideration. So must be performed or offer to perform binds who has be binding. A person who has entered into a contract will be binding. Not only him, sometimes his legal heir will also be bound when it comes to performable. So basically when it comes to the first point of who will be performing it, it will be either himself, when it can be done by an agent or a subsequent party, it will be done by them. When the party is promising that he will be doing it personally, then we can do only by whom? It can be done only by the party, not by any other else. He has to perform. If the other person doesn't accept the performance, is not ready to take the offer of performance, then it is not the party who is performing's problem, then the other party would be the one to be at trouble. So I am ready to perform, you are not accepting it, and who is non-performing? You are only not making me non-perform. So later you don't have a claim on to me saying that I didn't perform, because I have offered you, you didn't take. I am offering to deliver the goods by today evening, which we have agreed. It is agreed by us. Now you are saying that no, you don't deliver it now, or when I come to your home, you are not accepting the goods. So it is whose problem? You are failing to accept, so it is not my problem. The promisor will not be responsible for non-performance if the offer is rejected. Offer for performance is not the offer which we are looking at first. This offer for performance is rejected, then it is not my responsibility, it is your responsibility. Then when it comes to the refusal of performing wholly, there is a contract which should be performed wholly. There are 5 parts which you should do. Only after completing these 5 parts, I will be paying you. You have not done the second part itself. Should I pay you or pay you for the first time? If the contract is for the purpose of entering into it in a whole nature, then it has to be performed wholly. So I am going to enter into a contract with you for making interiors, including flooring as well as the ceiling, false ceiling, painting this area, right? And electrical wiring has to be done. You did 2 jobs, but you don't do the other thing. But the contract is for wholly performing it. So you have the concept of possibly recovering those costs, that I am not agreeing, not denying the fact. Okay, but when it is specified in the contract should be done only, performed only to be wholly done, then the other party cannot escape the provisions. So you have to do it wholly in order to enforce the contract. Otherwise, it will be said as they are not performed. The performance will not be considered. It's not wholly done. Then who has to perform? Person to perform is we have already taken up, where it is possible to be performed by anybody else, it can be performed. In case if he has promised that I will be performing, then he can only perform, not other parties. Right? Then when it comes to time and place of performance, very simple 4 lines, which would be like heading 1. If the no time is being specified, when you have to do? No time specified, reasonable time, right? Time is specified. On the specific time, you need not require for an application. Neither no time is specified, you are not even agreeing for the time specified. Okay, it says that whenever you are ready, come and collect the bike. The bike is ready, right? Bike is going to be ready. I am saying that when you are coming, come and collect the bike. So what you have to do? You have to come and apply for delivery to be taken. So I am here, please deliver the bike. So performance fixed time is not there, or reasonable time cannot be accepted, where the application for performance should be made, then it will be. So in practical, we have to see it in the 48, 47, 46. The reverse order, if you find where you have agreed that you have to make the application for performance only when you come and ask, I will be ready to perform 1. Or we have agreed already that this is the specific time, we will be specifying on the specific time we will be performing. On the other category where there is no time specified and no application is required, I will be performing it within the reasonable time. So that way they are to be read, right? The last one is where with respect to the place where it has to be done. It has, in case it specifies a place, it has to be done in that place, or a reasonable place. What is a reasonable place? Where you can find this person. Deliver it to me. Deliver this washing machine. Right? I know your home address as well as your office address. Where would it be delivering? Home. What you are going to do with the washing machine at your office? Right? So it has to be reasonable place, right? So reasonable place should be, even if it is not fixed, you can deliver it to the reasonable place. Reasonable place is not only with respect to this, reasonable time. At what time? In the normal house. Normal hours I should deliver. I cannot knock your door at 3 a.m. in the morning, say that I have come for delivery. Not possible, right? So all those things are time and place of performance to be entered into. Then what about the joint liabilities and rights? Devolution of joint liabilities, there is a concept where A, B and C are jointly taking a loan. B dies. Who has to repay? Representative, right? So B's heir will be paying on behalf of B. What about other parties, A and C?
Yeah.
So A and C along with B's heir, they will be performing. So it is basic line is that the survivor along with the representative should be performing. In case all the 3 has been died, all these 3 representatives should be performing. So devolution of joint liability will be on all the joint promisors or representatives shall fulfill it jointly, right? So similarly, who can compel the performance? In case of a joint performance is going to be done, obviously A, B and C are going to perform it together. I am demanding it to A, pay the 3,000 back to me. A pays the 3,000 back to me. Can he demand the other parties from that the same amount which they have to receive? Obviously, he will be able to demand. When I make a demand for the payment, A, if I am making, A has the right to call for the other 2 parties. See, he has asked money, give 1,000 rupees each. Only then he will be able to perform. Right? So there is a compulsion of a performance which can be done by the joint parties. Not me. I am not going to ask all 3 people. I'll ask only one person or any 2 of them or 3 of them, even for a third of them. It is between them to compel the performance of the other party to perform. Right? They have to contribute as per the ratio which they have jointly agreed to. Clear? Then release of one promisor will not automatically release the other promisors. So one person is being relieved. So okay, B dies. So I'll give some leeway to him. Let B not be included or B is you both pay. Then they cannot say that you left B. No, we are also to be left. We should also not pay. So that you cannot take. Release of one promisor will not allow an act of releasing the other promisors or their representatives. Reciprocal promises. There are few provisions relating to reciprocal promises and appropriation. When you go for simultaneous performance to be done, where together it has to be performed, it shall be performed together only. Meaning A sends the goods, B has to pay. A again sends the second tranche of goods, B has to pay. There are promises continuously happening. So only when the other party is ready to perform, I will be performing. I am not tomorrow you need this goods. I have not started the work yet. Whether you should be ready with the payment to pay me. If at all you are not confirmed that I am going to perform, you need not pay me. So other party has to perform. Only then you will be able to pay. Right? On 30th of November, you give the goods, I will pay the money. You are not brought the goods, but I am brought the money. Should I pay you? Should I pay you? Why? Reciprocal promises. You have to perform something. Only then I have an obligation to perform against you. Otherwise, there is no performance. No need to perform unless other is willing to perform. And in case of an order of performance, which we said 1, 2, 1, 2, 1, 2, then what happens? Only if A performs the goods delivery, B has to pay. A performs the goods delivery, B didn't pay. Whether A has to send the second tranche of goods? No. If there is an order of performance fixed by the contract, then it has to be followed. In case if it is not being followed, the other party need not continue the performance, they can stop. Then, preventing the other party to perform is voidable at the option of the person who is aggrieved. So, I am trying to perform. If I deliver the goods, you have to pay. So, you are saying that no, don't deliver the goods now. Then, if you are preventing me to perform, then you are liable. Whatever the losses I am going to take up, I will charge it on you. Then, default in first promise, defaulter cannot claim the reciprocal must compensate. So, same here, whatever the order of performance we have seen, so that refers to first promise, where the first promise is not being performed. We need not perform the subsequent promises, which we already know. Then, whether it is a combination of promises, which is partly, first part of the promise is legal, second process illegal. What happens? There is a first contract where A and B is entering into a contract where he might be supplying some goods, B pays for it, good. In the second tranche, it is going to be illegal goods is being shared and payment is going to happen. So the first part of the contract is a contract because the goods are valid, the object as well as the consideration is valid and lawful. Second category, it is not that way. So when the first legal set will be contract and the second will be illegal, we will be calling as void. When there is a time is the essence of the contract. What do you mean by time is the essence? We say that 6:30 is the time which we have to enter the class. It is the essence of the class. What can I do after you enter after 6:30? I can restrict you not to enter the class, right? In that case, I am specifically, when it is applicable, when I say specifically, time is the essence, right? So if I am saying that you have to deliver the goods on so and so day, the example which generally we take is, let's assume there is a sugarcane harvest happening and you are demanding that on January 10th, please ensure that the sugarcane reaches the market to my godown on the market. Time is the essence of the contract I am mentioning. Now, you are bringing it on 13th. Almost the sale for January Pongal is over. There is no way I am going to take a same amount of profit if I reach some 13. What I would say? I don't want your goods at all. Because you have delayed the performance. Where I told time is the essence. So in case if the contracts has something, you can see in few of the contracts where they will say time is the essence of the contract and add liquidated damages. In case of delay, I will be charging you delayed charges. So here, when it comes to the time is the essence of the contract, it will be voidable if the time is the essence and performance is being delayed. If you are performing it after the time period, I will say that I will not accept the performance, or I will just say the performance is delayed, so I might have to reduce the amounts only then. If you are saying this into the agreement, you should be very careful. If you are committed to the time is the essence of the performance, it is as good as if you don't perform in time, it is not accepted as performance at all. They can always come back to you and say that you didn't perform within the time, so you have failed, breached that way. Then appropriation of payment, which would be a topic as well. Appropriation of payment between parties. Here is the only place we are going to use debtor and creditor. How to appropriate payments? The debtor is making payments to the creditor. Multiple payments he has done. How to adjust this? There are multiple invoices, multiple payments has been done. How to adjust this? How to adjust? There are three scenarios which they are looking at. How to adjust these payments? Have you come across this? Yes, obviously. How? Let's assume you have initiated 3 invoices to me. 10,000, 10,000, 10,000 each. I am making a payment of 12,000 to you today, against which you will be adjusting it. Against which you will be adjusting it. Invoice number 1, 2, 3 are there. 10,000, 10,000, 10,000 each. And I am paying you 12,000. Against which payment you will be adjusting. There are multiple options you might look at. Sir, first invoice 10,000, second invoice 2,000, other things I'll keep pending, or I will divide this 12,000 into 3, 4,000 for each invoice I will deduct. All these are our perceptions, what law would say. So it starts with option where if I even mention it, I indicate that this 12,000 you consider it for the invoice number 1 and consider 2,000 for invoice number 2, then you have to adjust it in the manner I indicated. So indicated debt which the debtor indicates, you follow that, you don't have an option. If I don't say that, then you are at your liberty to choose. What you can do is, you can adjust the invoice number 3 and invoice number 2 you can adjust this 2,000. Invoice number 1 and 2 which is unpaid, 18,000 will be still pending. If you want to claim interest, the first invoice with the oldest, you can claim a higher interest. It is up to the option. When I don't indicate, it is you. Otherwise, it would be order of time, where chronological order. First invoice should be taken and paid first. FO, which we do with the inventory, no. Similarly, the first invoice has to be taken into consideration for payment. All these things comes under the appropriation of payment, which is a identical topic out of this, but I have just added so that we'll cover this somewhere. Clear? Clear? Yes. Now, next is on special contracts. Special contracts. We already know, right? What is a special contract? 4 special contracts which we see. One is contract of indemnity, guarantee, pledge and agency. Pledge, we also see bailment and pledge together. Then we have agency, right? So when it comes to contract of indemnity, what is the word indemnity means? Protection against losses or security against losses. Very good, right? So when it comes to protection against losses or security against losses, one party agrees to take, I will protect you. The party who is taking that promise is called the indemnifier or the promisor. The party who is getting protected is called indemnity holder or indemnified. Okay, so whenever he makes a loss, he undergoes a loss, this person has to come and protect him, promise to save the other person from losses. Okay, so there shall be 2 parties, promisor and the promisee, who is indemnifier and indemnity holder. The purpose is for what? Protection of losses. It can be implied or right. And when it comes this in the contract of indemnity, when it becomes eligible. When it becomes eligible. Very good, very good. So it is going to be when he is being sued. When he is being sued, he can get this rights. So you can say that 124 speaks about the contract of indemnity, the nature of contract. 125 speaks about the rights of this indemnity holder. When he is sued, he will get the rights. And what rights he will get? He can recover the damages from the indemnity fire. What damages? He paid in the suit. Whatever the damages he has to pay in the suit, which is raised against him, it can be recovered from the indemnity fire. Recover of cost. Cost is defending the suit. Instituting and defending the suit, whatever the amounts, you will be able to do that. Recover compromise sums. All these things are going to be purely in case of the suits which is going to direct him, pay damages, pay the cost, pay the compromise amount. Okay, all these things are by order of the suit is going to come that he can claim with the indemnifier. Apart from that, suit for specific performance to be done can also be claimed against him. Okay, so these three things are there. Indemnity holder can access to these three rights mainly from the indemnifier who has promised to save him. Right? Good. That is easy one. Then when it comes to contract of guarantee, how many parties is involved? Three parties. Surety, creditor, and the principal debtor. Principal debtor is the person who has taken a debt, and if he is going to default, who will come into the picture? Surety will be coming into the picture. So creditor is going to give a loan to the principal debtor, right? And in case if he fails, he will be the person to pay. But he fails, who will come into the picture? Surety. The creditor can go against the surety. So the definitions of these three people will be running around the definition itself onto the word called guarantee. They will say the person who gives the guarantee is called surety. A person on whose behalf guarantee is given or for whose performance guarantee is given is called principal debtor. Or a person to whom the guarantee is given is called the creditor. Around this guarantee word itself we will be looking at. Right? So it is a tripartite agreement. What do you mean by this? Three parties are there. There's a tripartite agreement. Then the essential shall have, the valid contract of the essential shall be there. The consideration which is passed from the creditor to the principal debtor is enough for the surety to perform. Surety cannot ask another performance for himself. Whatever he has performed, the creditor has performed from principal debtor is enough for the surety to perform. The competency of the party shall also be there. It should be a recoverable debt, not a debt barred by limitation. Then no misrepresentation or concealment should be there, because if the surety is being taken, the guarantee from the surety is being taken or mistake of information or misrepresentation or fraud, it will be valid? No. The surety will say that no, they acquired this in fraud, so I will not really take any responsibility. So you should not be having any misrepresentation or concealment of fact. The conditional liability shall be there. How much they can go against? How much is the quantum? How much is the quantum which the surety can be made responsible for? Right? How much he has agreed to it. You cannot claim more than what he has agreed for. 1 lakh is the creditor has taken from creditor has lended to the principal debtor, and the principal debtor has agreed that 1 lakh plus whatever the interest rate, right? So the surety is going to give a confirmation only for this principal amount plus the interest rate, whatever you agreed for. You cannot claim anything more than that. You will not be agreeing to that. Then with respect to concurrence of all three is required. All three has to agree for the purposes of a contract to be established for a contract of this thing. How can it be? It can be oral or written. Right? The rights of the surety. What are the rights a surety can exercise against the principal debtor? What are those rights? To recover the amount, because on principal debtor he has already paid the amount. Let's assume there is a lender, you are all the sureties and I am the principal debtor. The creditor has lent a loan to me and I failed to pay. You being the sureties paid to them. Now, do you have the right to recover it from me? Absolutely. So that is the right to recover from the principal debtor. right? You have right against creditor. What are those rights? Very good, very good. Some securities I might have given to him for the purposes of this loan. So once you have paid the loan to him, you can have the securities in your custody until he pay it to you. So that against the creditor you will have. Then against the co-sureties to the other parties to be brought in. So they will also to be contributing against co-sureties. If you are multiple sureties are co-surety comes in where at what place? More than one surety is there. So you are all together paying it to him. Then of other parties has to come. You will not be the individual to pay. 1 lakh is required. You three have agreed for making a payment. So then you three has to come together to raise this 1 lakh. So you have the right to demand the other parties to other co-sureties to join while repaying the loan. That right you have against the co-sureties. The discharge of surety shall happen on in case of a revocation. Revocation means what? Cancellation, either by himself during his lifetime or after his death, it automatically gets revoked, right? Notice or either by notices during his lifetime. He itself says that I don't want to continue this, don't want to continue with surety. I am withdrawing my surety against this principal debtor. So in those cases, it is revoked, or due to the death of the surety, it is getting revoked automatically. Then there will be novation of the contract where you change something, substitute the contract entirely. By that way, also revocation may happen. When the by creditors act, when the creditors perform something, he is extending some timeline to me to pay, giving some within us. We all three are parties, but he is giving some benefits to me, giving an extension of time. Then you are not aware of it. Can I keep extending the time without your consent? You will not be happy with that. So in case if any sort of creditors act which is not known to you, which is allowing a some sort of benefit or compromise to the principal debtor, even then the surety can claim. You can claim that no, because your act has been not good, right? So it is not in favor of you, the sureties. Let's assume you have made the payment. In the meanwhile, he has delivered the goods to me. What happens to you now? You have lost the right of securities. Those goods which could have been taken as securities until I repay, it has been issued to me. It has been delivered to me. Now you are going to lose your eventual remedy. Now this entire 1 lakh is going to be only recoverable from me. I didn't even pay the creditor. Why I am going to pay you? Then there is no options for you to recover the amount. Who did this act? The creditor has did this. Creditor should eventually do what? You should have delivered the goods to you because you paid the amount, defaulting amount. But he has delivered the goods to me. In those cases, he is blocking your eventual remedy. In that case, you can go against the creditor, where in case of any variation, release of the principal debtor, compounding or impairing the remedy, loss of security will be against the creditor. You can go against the creditor. By invalidation, where these areas, the surety can say that whatever the guarantee which has been given by concealment of fact or the no other co-sureties lacks essentials. So all those cases where you can escape yourself by invalidating. So I cannot say it is a valid, it is invalid because my guarantee was obtained through unfair means. Those cases can do. Right? There are exceptions where agreement with the third person or mere forbearance. This is for this revocation, the Creditors Act and all that, right? There is mere forbearance means what? Mere forbearance is delay. I didn't raise a suit against you. For that I can say that I have already left you. The creditor or the creditor has not raised a suit against the principal debtor for non-payment. Can we say the creditor has waived off the right against the principal debtor? No, he still have for 3 years, right? So you cannot say mere forbearance to raise a suit or any of the other categories might not be the case to escape from the liability. Neither the principal debtor nor the surety. Creditor's failure to increase or one of the co-sureties is being released, then there is a possibility of the other sureties to agree and bring in a new person, or they agree to revise the amounts which they are contributing to the guarantee. All these things should be seen together. It doesn't give an escape route to the surety or a creditor to go away. It always have a conditional coverage over the contract of guarantee. Right? There are few exceptions which they have given. Then, when it comes to next category of bailment and pledge, both are in similar nature. What is the only difference? Yes, this is for what purpose? Here they can say the purpose. What is this purpose? Some purpose, right? Here some purpose. Here what is the purpose? Security is the purpose, right? That we clearly know. So bailment is basically delivery of the goods for the purpose to be returned after the accomplishment of the objective. The person who sends the goods is called, delivers the goods is called bailer. Person to whom the goods is delivered is called bailee. What is the purpose of the goods to be delivered? Some purpose to after returning it after the purpose has been accomplished. So the essential shall be delivery of specific goods. The purpose is to be for some purpose, and return or dispose to that. The person in question becomes the bailee. Person in position where in case even if he is found from the road, even still they will be referred to as the bailee. Right? This is very common. After the purpose is accomplished, what you will do? You will give back the goods to the original bailer from you received it. Same application when it comes to pledge. What is the purpose of the pledge here? Same goods are going to be delivered to the other party, but what is the purpose here? Security. For what? Very good. So for the payment of other party to receive a payment to be done or a performance to be done. We'll take an example of the goods being delivered to you. I am a bailer, I want to deliver the goods to you. After 1 month I am going to take. Very normal. Instead, in case of a pledge, I have already taken a loan from you, against which I am delivered the goods to you. When I can take back the goods? After 1 month? Not only after 1 month. Only if I pay my obligation to you, you will be releasing the goods. Right? For some purposes, after the accomplishment of it, after the storage time. But in case of a pledge, what it is? As a security, is given as security for the performance which I have to perform against you, or the amount which I have to pay against you. So until I release that amount, you will not release the secured goods to me. So the purpose of the goods is being deposited with you is for the purpose of security. For the purpose of security. Only when I complete it, you will give it. So here we will be having the bailment of the goods as security for the payment of the debt or performance. The pawner or the pledger, the bailer is basically the pawner or the pledger who is the owner of those goods. Then pawny is the pledger, is the one who is taking that as a security for the purposes of it. Then there will be bailment of security. The goods exist and the delivery shall be made to the pledgee. What are the pawny's rights and duties? The pawny's rights and duties are what? Shall retain the debts for expenses, retain the debts / expenses, retain for subsequent debts and extraordinary expenses, sue or sell on default. What are the rights he has? In simple, while having these goods, he might have to go for certain expenses to be made, necessary expenses, he can claim over it. Right? Retain for subsequent debts, can he do that? I am taking 1 lakh from you, for that I have given a goods. Subsequently, I am also taking in 5,000 from you. Can you extend that goods to 1,05,000? No. Yes. What is it? Yes. If agreed. You can definitely extend it. We are not saying no. But at the time of giving 5,000, you have to say, hey, not only for 1 lakh, yeah, this 5,000 also I am going to hold the goods to you. Because there is a retaining of the goods under this provision, you can say, no right to retain the other prior debts, Only for the purpose which I am raising the debts, I will hand retain it, not for the other debts or prior debts or subsequent debts. If I have to extend it to it, what do you have to do? I have to make use also to presume to cover subsequent advances unless the contract when me because you can do that. You have mention it accordingly and say that for this also I am going to hold it. Then it can be done. Otherwise, you cannot extend yourself for subsequent days. Okay. Then extraordinary expenses, if anything is taken, you can still recover it. Then when it comes, the other party doesn't pay. What happens? I am not paying to you. What you will do? Sell the goods and recover the goods. Right? When you sell the goods, you are getting an, you have given for 1 lakh, right? You have given me 1 lakh, what I have to repay? For that only the goods has been given. You are recovering only 60,000. What you will do? Ask what? Ask what? Give me money. What do you will ask? Yes, the goods which I have given for security has been, you will be selling it. If I don't pay, you will be selling it. But the sale only goes for 60,000. What you will do? You will accept, okay, 60,000 is what, it is fine. Or what else?
Please.
Sorry?
Recover the losses.
Yeah, balance whatever the losses is, you can still recover the 40,000 from me. 60,000 is the sale value, still 40,000 is your loss. You can come against me for the balance 40,000, no problem. What if the goods are sold for 1,20,000? You have to give the profit. You have to transfer the surplus to me, because this is going to differ in case of a sale of goods act. Tomorrow when we see the sale of goods act, same concept. Please will refer this story there. Okay. Now we are saying that in case of a lesser amount, you can still recover that from me. In case of a higher amount, you have to share it, because who is the owner of those goods? Who is the owner of those goods? Who? Who is the owner of these goods which you are selling? Who am I? You are Pawnee, I am Pawner. So I am the Pawner, I am the owner of the goods, I am keeping the goods with you as a security. So whose goods it is? My goods. You have sold it and recovered the amount more than what it is actual, which I am payable to you. So you have to transfer the benefits to me, because being the owner, I have any rights over those goods. It is going to change in case of a sale of goods act. We'll see what it is, how this is going to take a change, right? So that we'll be seeing later. What are the other duties which has to be taken by the Pawnee? It is not only to the Pawnee, it is for the Bailey also. It has to take reasonable care of those goods. In case if it has to be used, not to be used without authorization, he has to have it. So it has to take reasonable care. No unauthorized use should be taken, and no consistent act. Whatever he does, that only you have to agree, not more than that. He has given a contract that you will be using only for the purpose of this. I am saying that for your personal use only, I am telling, but you are renting it. Can you do that? Then you are inconsistent with based on the agreement, right? So you have to return the goods on repayment to the other party. Whether you can mix the goods with the approval of the bailer. Generally, this comes under bailment. Here it will not be reflecting. So we can mix it with the approval of the bailer. You can mix the goods. In that case, the goods are mixed. You will have the proportion of what the goods are. Accordingly, you will be receiving a price. But in case if you don't have the authority to mix the goods and the bailee or the pledgee has mixed the goods, what is the option? What is the option? There is goods which has been mixed. What are the options now? You have mixed the goods. Whatever the goods I have given you, you have mixed it with your own goods. I come with 1 lakh and asking for the goods. You say, sorry, the goods has already been mixed with it. What will be I demanding? Loss. What if the goods are identifiable? Separable. There is a provision, right? There is a provision which says in case of a mixing of goods without the authority of the bailor, the same applies to this also, right? Where the goods can be separable, what you can do? Separate the goods. The cost of separation shall be borne by pawnee or the bailee, right? Same applies. Then, when it comes to non-separable nature, then pay for the losses. Compensation, you have to compensate since it is not possible to bifurcate the goods, separate the goods. The same applies here. What about the word called accretion? Accretion. Addition in the value. It has to be transferred to whom? Pledger, right? He is the owner of the goods. Any value addition should be taken. This also applies to the bailing also. Bailment also the same concept. We would have seen the example generally, right? A person who is bailing out he is delivered as a part of a deilment a pregnant cow. When it is being returned, the cow as well as calf should also be given. That is the return of accretion. I have pledged the cow at the time of when it is pregnant. So subsequently I am going to pay and get back the cow. During this, the cow has given birth to calf. What you should give? Both cow and the calf. That is the return of accretion to be taken into consideration. Right? So this we have already seen. Whether a mercantile agent can pledge the goods, pledged by mercantile agent. Right? Pledged by mercantile agent. Can it be valid? Who is the owner of those goods? Pledger. Whether the mercantile agent can pledge the goods? When? Sorry? When? In ordinary course, when other party has approved it. I am the owner. I am giving you for sale. I am also giving you the authorities that if you want, you can also pledge it for your purposes. Then with the authority of the owner, the mercantile agents can pledge. Otherwise, you cannot do. Valid the pledge if the agent in possession of the consent acting in ordinary course and it has the other party, whoever is taking the goods, has no idea that he is not the owner of the goods. He is taking in good faith, then the pawning can happen. Right? So with the authority or the consent of the original owner, and for the other party, the pawnee is not aware that it is not his goods, then also you can go. Then contract of agency, the last contract in the special contracts. What is contract of agency? To do any act or represent. Very good. To do any act or represent on behalf of another party. A person who is appointing a person to act on behalf of him will be called as the principal. The person so appointed for representing the other person or acting on behalf of the other person will called be as an agent. Right? So agent principal relationship exists. Right? The creation of an agency, how it can happen, either by words spoken or written, or inferred from a relationship, which is estoppel, holding out, and necessary. What is estoppel? Pretending. The person pretending to be an agent. I pretend to be an agent of yours and acting. Then I will be considered as an agent. You are giving a word that I am your agent. I am keeping silent. Then it is called holding out. Right? So somebody else is representing you as an agent, but I am not denying. Estoppel, we have to see the small line of difference. Estoppel is pretending myself. I myself pretending it. Holding out is where you pretending, I am not denying. Both the cases, the agency is being created. Agent by necessity. Emergency. In case of emergencies, there is a necessity that one person has to take control of the other person's affairs and do some act. So in those cases, other person is acting on behalf of the principal and he becomes the agent, even though there is no agreement as such. They never agreed that you become the agent, I will become the principal. No. But in order to do the job in case of an emergency, there is a necessity for the other person to be acting as the agent of the other. So the agency is being formed. What about this ratification? Approval after the act has been performed. So when the principal is giving certain rights to the agent and the agent performs above it, then it needs to be ratified and it will be ratified as a whole. All transactions, when you're going for a ratification, can be only ratified as a whole, not by part. So subsequent acceptance of authorized act shall be decided by the principal, whatever he is not authorized. Right? And the operation of law treats one person as the agent of another in case of it is being limited. Then what are the two types of agents which we are looking at? Sub-agent and substitute agent. How the relationship works? Sub-agent is a person appointed by original agent. So as long as now we will be saying principal and agent. When it comes to the sub-agent concept, we will say principal, original agent and sub-agent. Sub-agent is the agent who is appointed by the original agent. Okay. Then you have two possibilities where we can be appointed with the proper authority of the principal or without the proper authority. Why it is necessary to understand whether it is properly appointed or improperly appointed. Sub-agent is obviously he is responsible. Agent is the one who is appointing him, he is responsible.
Providing one more agent without the knowledge of original agent.
Sub-agent is going for the next agent. Sub-agent, he itself is sub-agent.
Sub-agent appointed without authority.
Without the authority, who is responsible? Will be responsible? Now what we are trying to do are who an agent performs. Let's not go into the concept of sub-agent. Generally, an agent performs something. Who is responsible? Principal. For all lawful acts, they will say the language for all lawful acts. Who is responsible? Principal has to take responsibility for all lawful acts. Now, under this category, a sub-agent has been appointed under the control of original agent. Now we are looking at whether the principal is responsible or not. For agents thing, principal is definitely responsible. We don't have a doubt. What about sub-agent? Whether principal is responsible is the question. With authority, he is responsible. Without authority, he is not responsible. That is the one line which we have to remember. So, principal is not responsible. In case if it is not appointed, who is responsible then? Sub-agent himself will be responsible. Original agent will be responsible. Right? So, we'll come back here in simple terms. So, in case of a principal, original agent and a sub-agent is being there. If the sub-agent is being appointed with the authority of the principal agent, which is given to the original agent, right? So, principal is given the authority to the original agent to appoint as much as sub-agent he wants. In those cases, the sub-agent's act will also be taken responsible by the principal. If he is not giving any authority, but the original agent arbitrarily appoints himself sub-agent, then the principal is not responsible. Only the original agent will be responsible. That is in case of a sub-agent's concept. What about the other agent? One substituted agent. Who is the substituted agent? Name. The original agent will name another person or refer a person. That person will become the agent of whom? Principal himself. Very good. So, when the agent of the principal will be entrusted for the business of naming somebody, the other person who is named by the original agent will be called as the substituted agent or substitute agent. He shall be responsible. Right? So, in case of anything goes wrong when in the performance of substituted agent, who is responsible? Who is responsible? You are asking me, let's take an example. I am your company secretary. Example, you have a company, I am your company secretary. You are asking me or a consultant whom I am providing CS related services. right? You are asking me, I need a legal case to be fought. Refer some of your any good lawyer. I am naming a person. So you are my principal. I am your agent, and a person whom I am naming is called substitute agent. If I am going to appoint under me, it is substitute agent. Sorry, sub agent. In case if I am going to name a person, it will be substitute agent. He will be acting for whom? Me or you? Principal. They will be acting for you. Okay. In acting of the performance, he has failed you in the suit. The suit got dismissed or the suit didn't go well for you. The principal has to go for a loss. Can you claim against me? No?
If we recommended the name as if it was done for
Very good, very good, excellent. So, as a man of ordinary prudence, as if I in his own case, but all I had to appoint in that case, I have exercised ordinary prudence in selection of it. As a man of ordinary prudence, as if my own case, I have selected this person. I have same way I have done all the research and selected the person given to you. Then I am not responsible. But I randomly gave you some name, and because of that the person lost your case, then you can still hold me responsible. When I have exercised caution, exercised the ordinary prudence is knowledge, prudence is nothing but knowledge. The ordinary prudence, while selecting a substitute agent for you, I have done my job well. Even if the other party fails, I am not responsible. But in case of I fail, negligently made a choice, and because of that you have to undergo a mistake, then it is responsibility on me, and I am liable to you. You can still claim liability, right? We'll complete this e-contracts and take a break and come back for two other pages, which is on discharge of contracts and remedies relating to discharge, breach and remedies. Okay, what is an e-contract? Which is very simple. Electronic contracts, right? How it is being created? Signatures, physical signatures, digital signatures. Who issues digital signatures? We would have seen something like controller of certifying authorities. Certifying authorities issue these signatures, which will be like pen drive, right? Which will be like pen drive. So it says, what is e-contract? How it is getting its significance? It is paperless contracts, and it improves your speed, accuracy, and reliability of things. You need not wait for all the way to get the contract signed up. Physical, sir, the person is traveling, sir. Only when he is back after a month, we will be able to sign. No way it is required. Now you can affix his digital signature from wherever he is. Affix his digital signature, which will be taken validly as though he has signed it. Right? It requires a digital signature to authenticate it. It is also recognized by the Information Technology Act 2000, which is amended in 2008. It accepts this, right? So how this entry works is, originator is the person where from the proposal goes in. The intended receipt is called the addressee. This name is just for the purpose of mentioned is, in case if at all there is a chance to ask a very hard question, then will be only on originator and addressee. Person from whom the message is sent, we call it as originator. Who receives it, we call it the addressee. Very least chances, but we are preparing for the toughest question. That's all, right? Addressee, and accordingly he might accept or reject the loss or offer, right? As long as this email, let's assume it is going to be email, which I am sending an offer to you. You are accepting the offer over email. Whether a contract is being formed?
yes.
Promise is formed, yes. Only thing is, you will be able to show this as a proof. Yes, we had an offer, we had an acceptance, we considered, we made a performance, all these things are included, right? So, when you look at the validity of the e-contracts, this part, it is enforceable under the Indian Contract Act. As long as all the 6 elements is also present in this e-contract, you can still enforce this as a paper contract, no problem. Clear? Right? So if at all But it's question if whether e-contracts are enforceable. Yes, any contract, e or paper, is enforceable only if the 6 elements is present. Even in e-contract, it could show the proof of 6 elements is being present. You will be able to consider it to be legally enforceable, right? The types of e-contracts, they are giving 3: browse trap, shrink wrap, and click wrap. Where browse trap is where while browsing website, you will say accept cookies in order to see it, right? See this information, right? In those cases, they will say browse trap. So soon after you click accept all cookies, then they will allow you to browse it. So that is agreement you will say by accepting cookies, right? You will allow us our cookies to be part of your system. So we are allowing it. We are entering into a contract, right? Then shrink wrap is where you install softwares, right? When you install a software, do you want this software to make changes to your C drive? You click yes, so it will start running background. So shrink wrap is like, will be like an open window. It will open and you say yes, I agree, close. Then it will minimize and go start and installing, right? So that is called shrink wrap. It shrinks, right? It shrinks after you accept it. Click wrap is where it will ask you click here to accept the terms and conditions. When you go for a software purchase agreement, it will ask you, you agree to the terms and conditions of Microsoft. By clicking here, you agree to the terms and conditions of the Microsoft. And you click here, then submit. If you don't click, they will not allow you to submit at all. So those categories are I agree or I consent. Even in the exam form, no, when we file for examinations, other things and all, every information will be filled in. It will ask click here so that you confirm that all the above mentioned details are correct. Only then it will allow you to go for an next level, right? So that will be called as click wrap. Only if you click, it will allow. Where when you are clicking, you are what you are doing. What you are doing when you are clicking? What you are doing by way of clicking? You are agreeing. You are agreeing to what? The contractual terms. You are entering into contract. You are entering into contract. So that is what here it is being mentioned. The validity of e-contracts is also these three things also would be considered to be e-contracts. They can still force you. You will say that no, I didn't agree for it. They will come up with this. You remember while purchasing our software, you entered, I click. By clicking this, I have entered into a contract. So that is still applicable. That can even be enforced against you. Clear? Clear? That is e-contracts. Good? Good. We'll take a break. We'll take a break and come back for last two slides on the Contracts Act. Clear? Yes, the last part of Contracts Act will involve discharge of the contracts and breach and remedies of the contract. So discharge of the contracts means what we understand. Discharge. Is it only when they perform? Cancel it also. When they terminate it also, the obligations comes to an end. So what we are trying to establish is in case of a discharge, the obligation comes to an end. How it can comes to an end? For various reasons. Majority predominantly whether they have performed it or they have cancelled it. So how it is going to happen? We have seen here. One is where discharge by performance, where either they have performed it, actual performance has happened. Discharge by performance, where the actual performance has happened, or they have attempted the performance. This is what we take it as performance. Their offer for performance will also be considered as performance. A party who is not accepting the performance being offered, he will be the one to be liable for subsequent damages. You cannot blame the person that you didn't perform it. He has attempted to perform, right? Then, when it comes to agreement by discharge way of agreement, what sort of agreement which we are looking at? These agreements are basically between parties. Mutually, they are agreeing on something. What they are agreeing? Either to novate. Novation is where? Substitution of a new contract in place of an existing one. What happens to the old contract? It need not be performed. The obligations under the old contract comes to an end. New contract will be performed. Old contract, no. When it comes to alteration, small changes, one or more terms of the contract is being changed. Right? We'll say no. The house is being altered to renovated to different. Small alterations being taken place in the part of the house. We call it as alteration. In case of a totally different look, you are going to give this renovation. So renovation we are doing. So same way, renovation is substitution of a new contract in place of another. But in case of an alteration, is one or more terms of the agreement is going to change. The new changed terms will be applying. What happens to the old terms? It will come to an end. There is no obligation to perform as per. Let's assume there is a old term of 30 days pay term. Now you have revised it to 45 days. So what should you follow? 45. So sir, old agreement says 30. Should I also follow that? No, it has comes to an end. So you have changed. When in case of a recession, what is recession? Cancellation. At the time of cancellation of the contract, you need not perform the terms which is agreed under the contract. Remission, lesser performance, now we are agreeing. How? Give me an example. Lesser performance, we know. Remission means lesser performance. Now give me an example.
I have to pay 1,000.
Yes.
But I have 900. I have accepted that 900. Afterwards, you can't ask me.
1,000 rupees, right? Balance 100 rupees, or can I say no, 900 only I have accepted now. 1,000 is the old dues. So I am supposed to receive 1,000. So there is still 100 balance. No. So very good. So what we would be agreeing under the remission is I will accept lesser performance. Then you cannot go back to the original performance and ask, oh, you are having 900. Then I will say, no, you have to give only 1,000. So you cannot go back. That is called remission. When it comes to a waiver, by way of an agreement, we are giving up the right to claim against you. So now I have given a waiver. Subsequently, I am come back and asking us, no, you have to perform. It cannot be demanded because by way of waiver, the obligation is being waived off, is being forgiven. You need not perform, I have told. So that case, it is being waived. Then, when it comes to discharge by lapse of time, time is the essence, and the time within the time you have not performed, then I will call it the contract is discharged, right? Where you have to claim for an amount within 3 years, you have not claimed. The court even will not accept the suit. If you are unable to prove why there was a delay, then the contract is discharged by lapse of time. Discharged by operation of law, whichever it is not coming under the other categories, where by way of operation of law, the law would allow you to discharge a contract. When the person has died, who entered into a contract has died, who sometimes you can go for the performance to be demanded from the representatives or the heir. But some cases where they have agreed personally, will not be able to do that. What happens to that? So where that becomes discharged by operation of law, they specifically said no. Terminate contract involving personal skills, where only that individual can perform, that is being made up a question, then it is here. Then when it comes to insolvency, the promisor becomes insolvent, how he will be able to pay? Then also the law would treat this, that person cannot pay, all the contract which he has entered into will be taken as discharged. Then when it comes to unauthorized material alteration, you have to relate this to this. Alteration is there, unauthorized material alteration is there. Right? How it is to be seen. Alteration is one or more changes. How it happens? Whatever here we are seeing is mutual. Mutual contents is that is changing. One person changes the contract, which is material means what? Material. Significant. Significant. Very good. Significantly changes the rights or liability of the person. Sir, initial was wrong. I have changed it. We can call it as a material alteration. No, it is an alteration. Material alteration is where it is affecting the rights or liabilities of the parties. We call it as material alteration. The other party is not bound to accept it. He can discharge the contract. Then in case of a merger, where the inferior contracts gets merged with the superior one. The superior ones need to be followed, inferior need not be followed, right? So we got example, we'll say I am a part-time employee who works for 12 hours per week and I made a full-time employee. Now it is 48 hours per week. What should I follow? 48 hours. I have converted myself into a full-time employee. Can I be demanded part-time 12 hours? This 48 hours, 60 hours per week you have to do. No, not necessary. So it has already subsumed. My full-time employment has subsumed the part-time employment. So the inferior will go away, superior will be there. Discharge by impossibility.
Why?
Discharge by impossibility, void. That is correct. Discharge by impossibility. It's possible when the act becomes impossible. Void because it is unenforceable. The event becomes impossible. Whether at the time of entering it is being, what is the ideology is there trying to invest there? If it is at the time of entering itself, it is impossible. You can call it void. You can call it void directly. Is that right? Time of entering itself, I am saying you know that this is an impossible act, legally or physically impossible. What you will say? This is a void contract. Now, was possible, but subsequently it became impossible. The horse would have been kept for sold, can be sold, but unfortunately it dies. Now it becoming impossible. Whether A and B can be questioned? No. Why? Impossibility arose. So in those cases, contract get discharged. So impossibility is void. Even here, impossibility is void. But the only thing is where becomes impossible. You have to look at becomes impossible. Earlier itself is impossible means directly void. Earlier it was performable. Now it has become impossible. You cannot blame anybody. So it becomes possible and discharge. The contract is discharged. Even the court cannot enforce you to do something which is impossible. Right? Then when it comes to discharge by breach, failure by one of the parties to perform, then you call it as breach. Right? Breach of contracts gives rise to discharge of the contracts. Not only to discharge, it also gives to remedies to be claimed by the other party. Right? So that gives us ways to the breach and remedies of the last part of the contract, where breach of the contract means what? Failure or refusal of a party to perform an obligation under the contract. Main other thing you have to look at is lawful excuse. Without lawful excuse. What is without lawful excuse? Sir, due to heavy rains, I couldn't make it to the class. I attended online. It's a lawful excuse. Sir, no, rain was not there, but still I attended online. It is unlawful excuse. Yeah. So that is for us to decide over it. So what is lawful is acceptable. There is a reason why you cannot perform. So because of what is acceptable is what we have to take, right? So during the COVID lockdown, I was unable to take my vehicle, so I couldn't deliver you. That is lawful excuse. Sir, my workers didn't work well. Because of this reason, I couldn't deliver the goods to you. Can I make it as a lawful excuse? That is your problem. Your worker doesn't work well. So it should be acceptable one, the lawful one, right? So those things will give rise to a breach. So in case if it is a matter of COVID and you didn't deliver, we will not call it as a breach. We will say that, okay, everybody has to face this. So we will not consider as a breach. We will give some time extension. That will be possible. Without a lawful expense, one of the parties fails to perform, I will call it as a breach. Breach can be of two types. One is actual breach and anticipatory breach. Actual breach consider the contract to be discharged. Actual breach has happened. The contract is discharged. He failed to perform. Anticipatory breach has two options. It will not discharge the contract as it is. You have options whether to consider it as discharge with the opinion of the other party. You can ask him, see, I understand that you will not be able to perform. You want me to treat it as discharge? That is one option. Or you can wait till the date, actual performance date, and get it discharged. So you see that during the performance, at the time of performance is due, we understand that he cannot perform. So you go and declare that the contract has been discharged. One party fails or refuses to neglects to perform, then you call it as discharge, right? So it discharges the contract, and right to sue for damages will be right away. It is increasing. Right away it has been filed for you. The actual date came, breach has happened. Then you have to accept the breach and say that yes, I'll pay for damages. I can claim for damages from you. When it comes to anticipatory, it is constructive. It has not happened. 22nd of November, you should deliver the goods. 22nd ended yesterday itself. You are not delivered. Actual breach has happened. If the delivery date is 30th of November, but I know that you will not be delivering the goods on 30th of November, whether we can call it as an actual breach? No, it is anticipatory breach, constructive breach, right? So it repudiates the liability before the due time, disables self from performing it. So in those cases, you call them as anticipatory breach. So it does not immediately discharge the contract. It does not discharge the contract itself. Discharge only if the agreed party accepts the repudiation. Only if he accepts it. Or I can wait till the November 38 and accept it as an actual breach. Right? So how it can be handled? It gives as an option for claim for damages is possible, right? So whatever the compensation for loss or damage naturally arose to likely to result in not for remote or indirect losses. So whatever the compensation in case of a breach can be claimed against the other party. That should be a possible loss, not a remote case of loss. In ordinary course of loss, we will see normal loss, abnormal loss. Normal losses and all will be taken up. What they are insisting, remote or indirect losses. So because you didn't deliver the goods today, I was unable to perform a product and that has caused me 2 crores of loss. Now I'm going to claim those 2 crores loss onto you. Can I say so? So you can see in any of the contracts, indirect or consequential damages are not possible. Neither party can claim indirect or consequential damage. Very clearly they would mention, because nobody wants to take that liability. Clear? They will be clearly mentioning it. Then it also says about when the penalty is not stipulated under the contract. Some contract would say, right? So in case of the delay, 5% of liquidated damages, delay charges to be paid. Or you have to, in case if the payment is not being done within the stipulated time, you have to pay 18% interest. So those are what? Already stipulated into the contract. The losses are stipulated into the contract. What if they have not stipulated? Right? So the reasonable compensation not exceeding the name amount or penalty may be charged. So reasonably they might be taking it. And a person who can claim this compensation? A person rightfully resigning it, rightfully cancelling it. You didn't perform, so I cancel this contract. Right? You didn't perform, only because of that I am cancelling this contract. I don't want to voluntarily cancel it. You didn't perform, that is a breach. So that I am cancelling the contract now. So he can claim compensation from the other party. What are the types of remedies when the breach happens? What sort of remedies can be taken up here is these 5 remedies. All these are going to be in the form of suits. Right? In the court only you are going to file this. Suit for rescission. Rescission is what? Cancellation. Cancellation of the contract where the agreed party free from obligation and he will be entitled to compensation. You are not performed. I will go to the court and say that, see, he has not performed. We want to declare the contract is discharged and also I have to claim remedies. Please give an order to that effect. You can file a suit for rescission. Suit for damages is wherever you hear the word damages, D-A-M-E-G-E-S, D-A-M-A-G-E-S, yes, coming now. Damage, there is a difference in law. Damage means actual injury. Damages means they will refer to compensation, monetary compensation, right? Damage means injury. Damages means it will say monetary compensation. So suit for damage is basically monetary compensation for loss or injury, right? The principle is compensation and not punishment. So they don't want to punish the other party, but they at the same time they want to give some remedy to the party who is affected. So we are calling it as compensation. Then suit for quantum meruit. What is quantum meruit? As much as earned or as much as performed. In the middle of it, I don't perform it. We earlier said that whole of a performance, if you are looking at 5 works I have to do to earn 20,000, I have done 3 works and I am claiming compensation, and if it is not a wholesome performance to be categorized, then I will ask for 3 performance I did right, please pay for me. So that level I can go as much as earn. Payment in proportion of work done can be taken up, and in case of a gratuitous act or refusal to perform or the contract is void, you will not be able to claim up this quantum merit. It has to allow. In case if it is a whole performance to be done, it will not be possibly to get, because the contract will clearly say that he will be eligible for the remuneration only if he performs in total. If not, it is not possible. There might be some exceptions, right? Then when it comes to suit for performance, we will take it as a class. We will go to the suit for injunction. What is injunction? Restraining, stopping something to be happening. Put a pause button, right? You might file an injunction for the person is doing something which is going to cause you further losses. I'll get 2 small examples. Let's assume we had an agreement that I have a intellectual property which you are using, but you are using it for your own products. Quality is very low and my brand is getting affected. First, I will go and file, because the agreement would always say, when I am giving you the brand, you follow all my quality standards in order to sell my goods there, produce and sell my goods there. But you didn't follow that. You did your own formula and made the goods which is of low quality. What I will be doing further from deteriorating, right? My brand is further, it is going to deteriorate. The goodwill of the my brand is going to deteriorate. So for that, I will say first stop selling, stop producing, so that we will be going under injunction. This is one example, right? Or let's assume we have an order that you will be building a house on behalf of me and I will be paying you in parts. And at some point in time, I said that no, you don't build the house. Stop there itself, I will pay. But what you are doing, you are building, keep building it, so that you can get a higher compensation. So I will come an injunction and say, please stop. Court has to direct. I have already given a notice of stoppage of work on 20th of November itself, but he is still not stopping. He or she is not still stopping. So court give an order to stop them, restrain them continuing the work. So in those cases, we call court order from restraining a person to doing an act. It's a preventive relief to reduce the losses or stop the continuing losses. I can go for a preventive relief, which is called an injunction, right? When it comes to the last part of specific performance, when the damages are not enough. Specific performance means do the thing, do what we have agreed. I don't think anything else. I want you to do what we have agreed. When the compensation, monetary compensation, inadequate, it's not adequate. Even if you compensate, it will not be possible to be adequately helping my loss. Then what will it be demanding? Do the work I don't want. What is the example which we generally speak about? Right, very good, excellent. So there will be cement bags which I have agreed to buy from you, which is costing 250, and even we have a clause in case of a delay, you will be paying 10% as liquidated damages. So on the given day, you didn't give the cement bags and you are ready to give the compensation of 25 rupees. 250 rupees, the bag is 25 rupees, you are ready to give. But when I go to the market, it is 300 rupees. Even if I take your compensation of 25 rupees, I can only go up to 275. Now I have to purchase for 300. Another 25 rupee loss is there. What I will do? This compensation I don't want, you perform. You itself get the goods and give it to me. Then I will demand a specific performance by filing a suit with the court. The court orders defaulting party to perform the profit act. You do the act itself. There is no possibility to monetarily compensate it. So inadequate monetary relief or not standard for damage compensation are obtainable. Right? You cannot identify how much is the loss. Then the court will decide. You are unable to decide, or whatever the amount compensation is inadequate for the party's loss. Better you perform the performance itself. That is the order which the court is inclined to give. So that will be the remedies. 5 suits there can be filed: suit for rescission, suit for damages, suit for quantum error, suit for injunction, and suit for specific performance are the suits which you can go against. Clear? Clear? So with that we will complete Indian Contracts Act. So we are also at the end of day 1. I appreciate on a Sunday you have taken all the efforts. Okay, even people who are online as well as you on a Sunday to take an effort of coming. So you already cleared your 25% of your professional courses, right? Your elevation. So 25% on foundation, 25 on intermediate, balance on the final examination. So good that you took some serious efforts onto this revision session. So we are end of day 1. In case of any doubts or clarifications, you can take it out now. And tomorrow we'll see the other 2 acts. Yes? Anything? No? We're all tired. Good. So we'll see you tomorrow. We'll start with the day 2's thing, which is Sale of Goods Act and Negotiable Instrument Act. Okay? Good. So since it is Contract Act today, it had taken so much of time. Tomorrow, the other 2 acts, literally, you know what is the content of the act. It might have a lesser amount of thing. If possible, we will have communication started up tomorrow, or we'll take it from the 3rd day. Accordingly, we will reduce the time up to it. Okay? Clear? Thank you then. See you tomorrow.